preliminary hearing and the request for removal as it relates to 3 minor children. May I have the names of our participants, please?
Lee Heiss, lawyer, guardian ad litem.
Ms. Faja Thomas, counsel for the department. Ms. Miles.
Deja Miles with the department. Thanks so much.
Michael McFarland, representing mother. Please introduce yourself.
Heather Boger.
Very good. I see we have Mr. Ballacino with us as well. Would you like to introduce yourself?
Yep, Austin Ballacino.
Thank you. And you are potentially the father of the youngest child, BB. Is that right?
Yes.
Thank you. All right. Do we have Anthony Fox?
Yep, here.
Thank you. And you are the legal father of the other 2 children, right?
Correct. Yes.
All right. So, Mr. McFarland, we made some time to allow you to talk to your client, yes?
I did, Your Honor. I can state my client's position. She has received the petition. She's read it. We do not need it reread. She has no Native American heritage, nor does she believe the fathers do. At this point, she's incarcerated, as we can see. And on the petition, there are allegations of violation of bond and drug usage, which would be contrary to the conditions of her bond. So we would like to plead no contest to this petition, Your Honor. I have advised her of her rights. I think that covers everything.
Okay. Deputy Ames, would you swear in Mr. Anthony Fox, Austin Ballacino, and Ms. Heather Boger?
If I might, Your Honor, I forgot, neglected one thing. She is satisfied with the proposed placement of the children as indicated in the petition.
All right, Mr. Ballacino, let's go back to you for a moment. I have a note in the petition. You're not a respondent parent in this case, meaning the department's not asking for jurisdiction over you specifically, but you also have not established your legal parentage of the minor child. Would you confirm whether or not the petition is correct when it says that you're requesting DNA testing?
I am not requesting, but
okay,
I am.
So
I'm sorry. I'm fully willing to if necessary.
all right. Well, in order to establish paternity, there's a couple of ways to do that we typically prefer, one of which is the DNA testing. The other is your signature as well as the signature of the mother on an affidavit of parentage. You could also file a custody action. That obviously would take a little bit longer through the courts, but that is another option. So I'm happy to give you some more time to do that, but I just wanted to let you know that in order to establish your legal rights, we'll need you to act on one of those affirmative methods. You're welcome to reach out to the caseworker, Ms. Miles. Ms. Miles, would you be able to help him with that? Okay. And I'll go ahead and put in the order to allow for DNA testing in case you change your mind, okay?
Okay.
All right. So for now then, for the rest of today's hearing, you'll sort of more or less be an observer at this point. But if you have any questions, just either raise your hand or give your hand and we'll try to do our best to accommodate that.
Thank you.
You're welcome. Okay, let's go over to Mr. Fox. Mr. Fox, would you mind coming to the podium for a moment so I can have you next to a microphone? All right, according to the, well, and I gotta ask Mr. Ballacino this too, just to confirm. Legal parentage and then also Native American heritage. So I understand you have signed an affidavit of parentage for the other 2 children in this case, is that right?
Yes, ma'am.
All right, so, and you are in the process of filing an action?
That is correct, yes.
What's the status of that?
Actually, it's going to be filed today.
Okay,
yes.
So we don't have a case number yet, but you're
correct,
looking at
yes.
okay. Yep. Do you have any reason to believe that you have any Native American heritage?
No.
Or? All right. Are you, my understanding is you're seeking placement of your 2 children, but your intention is to sort of share that responsibility with your mom, is that right?
Mother-in-law.
Mother-in-law, okay, well, that's great. Do we have any questions of Mr. Fox, Ms. Thomas?
No, Your Honor.
Okay, Mr. McFarland?
No.
Ms. Heiss?
He referred to Miss Gibson is his mother-in-law. Is there a marriage in this family?
No,
Okay, so, but it is the children's mom's mom, right?
that is correct.
I got it. Thank you so much.
You're welcome.
All right. Okay, Mr. Fox, you're not a respondent either, so they're not asking for you to be under the jurisdiction of the court as of today. So, and I think the plan is to place those two children with you. But again, if you have any questions as we go along, please feel free to raise your hand and we'll do our best to let you know what's going on.
Thanks, Shannon.
You're welcome. Go ahead and have a seat. All right. Mr. Valacino, could you also answer one more question for me, which is, do you have any Native American heritage in your family, if you know?
I do not.
Do you, okay, so I guess I asked the question kind of not the best. Do you have any reason to believe that you have Native American heritage or that your children would have any Native American heritage?
No, ma'am.
Thank you so much. Ms. Boker, can you hear me okay still?
Yep.
All right. You are the biological mother of all three children in this case, is that right?
Yep.
And you have received a copy of the petition?
Yep.
All right. Your attorney has said that you'd like to waive your right to have that read onto the record. Is that right?
Yep.
Okay. Do you have any reason to believe that you or your children would have any Native American heritage or eligibility for enrollment?
Not that I'm aware of, no.
Okay. Very good. Do you know, I don't have any evidence of this, but are your children, any of them, concerned by any other legal cases, like a guardianship or a support order or anything else that you're aware of?
No, absolutely not.
All right. So you have a right to an attorney, which is why Mr. McFarland is here. You have been named as a respondent parent, as you know. There are certain rights that come along with that, including the right to a trial. Mr. McFarland indicates you'd like to enter a no contest plea, and I'll go through your trial rights with you as you make that decision. But I trust you've had a chance to talk with him about that option. Is that right?
Yep.
Is that what you wish to do?
Yes.
You also would have the right to seek placement today, the right to admit or deny the allegations in the petition, make any statements of explanation if you wish. With the decision to enter a no contest plea, essentially what I would be doing is taking all of the allegations in the petition as essentially true. So you don't have to speak to those allegations. In other words, you don't have to give me a verbal confirmation, but I would be assuming that the allegations in here are correct. Do you understand that?
Okay.
Okay. Now I'm going to go with you the rest of your trial rights.
Okay.
If I accept your no contest plea, you are giving up the right to a trial by judge or a trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath at trial. The right to cross-examine those witnesses, of course, with the assistance of your attorney. And the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand that you'll be giving up or waiving the rights I've just explained to you if you enter a no contest plea?
Yes.
I'm sorry, was that a yes?
Yes.
Thank you. With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. With regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, ma'am?
Yes.
Do you have any questions about any of the information I've given you so far?
No.
Are you under the influence of drugs, alcohol, or anything else that could get in your way of understanding what you're doing right now?
Absolutely not.
Okay. Is anyone making you enter a no contest plea?
No.
Has anyone threatened you in order to get you to enter a no contest plea?
No.
Has anyone promised you anything in exchange for your plea?
No.
All right. Would you say your decision to enter a no contest plea is one you've made of your own free will?
Yes.
All right. Very good. Your official position on the request to enter a no contest plea, Ms. Thomas?
Your Honor, the department is agreeable to that.
Ms. Heiss?
I have no opposition.
Do you find it to be in the best interest of these children if I were to accept a no contest plea by mom?
Yes, Your Honor.
Very good. All right, Ms. Thomas, then, as it relates to the factual basis of the plea?
Thank you, Your Honor. I would ask that Ms. Miles be sworn in. Thank you. Ms. Miles, can you hear me okay?
Yes.
Okay. Can you please state for the record how you are involved in this matter?
I'm the CPS investigator on the investigation.
And as the investigator, Can you just briefly outline the process or your investigatory process used to obtain the allegations that you put in the petition?
So we received our complaint on January 26th. I went out to the home to see Heather and the children. That's where we discussed allegations. She did submit to a voluntary drug screen. And then after that, we went over the allegations. She denied that she felt like drug use was getting in front of her parenting. She denied that she needed any substance counseling or anything of that nature. But at that point in time, the children were at Dawn's house. They were safe, and she agreed that she was accessible to mom at any point if the children needed it. So that following week, when we received our drug screen results, I had tried to reach out to Heather, which she does not have a cell phone. So my point of contact was go through Dawn to try to reach Heather. At that point, Dawn indicated to me she had not seen or heard from Heather since January 29th, which would leave Briella ultimately without proper care or custody, as she does not have any other legal parent besides Heather. I continued to try to locate her by messaging her on Facebook, going to homes that she was speculated to be at. She was not there. I continued to call Dawn to see if she had heard from her or where I might be able to locate her. And I was not successful in any of those attempts to try to reach Heather. And at that point, the next time that I was able to make contact with Heather was this most previous Friday when I was serving her with the notice of hearing, and she was arrested for breaking no contact with her.
And when you were able to speak with Ms. Boker at her mother's home, to the best of your understanding, was that in violation of a previous court order?
Yes.
And what was your understanding about her housing status at that time when you spoke with her?
So at that time, she did indicate that she was being evicted from her home that weekend. And the only place that she had to go was her mother's house.
During your investigation, were you able to determine whether she was staying anywhere else that might be appropriate for her or the children?
So she was speculated to be at another person's house. His name is Andrew Jacobs, which we learned that is a speculated drug house. There was a raid at that home. And I spoke to the Rhino investigator on that raid, where he did indicate that there were several illegal substances found and that Heather was in the home as well. But she was not arrested and there were no charges against her, but she was found to be in the home at the time of the raid.
In the petition, there's an allegation concerning domestic violence between Ms. Boker and her mother. Do you know the status on that case at all?
As of right now, I believe the set court date that they have for that was March 5th for upcoming, but they still have a no contact order in place.
I'm sorry, who is they?
I'm sorry, Dawn Gibson and Heather Boker still have the no contact order. Thank you.
Thank you for that.
And is it her mom?
Yes.
Thank you. Sorry for the interruptions.
No, thank you, Judge. And as it relates to the two older children who have a legal father, the position of the department is to release them to their father under the supervision of the department. Is that correct?
Yes, that is correct.
And what is your understanding of the proposed arrangement between the family members?
So my understanding with speaking to Dawn and Anthony, Anthony has a work schedule that requires him to get up very early in the morning. So he does not want to wake the children up for that. So the children do stay at Dawn's. They sleep there overnight, but Anthony visits them during the week after work and gets them and takes them to his home over the weekends. And he is still very accessible, and they have plans to sign a power of attorney. So that way Dawn can still take him to doctor's appointments and handle any other needs such as school and services.
Thank you. And in the petition, you indicate that Mr. Balancino may not be interested in establishing paternity. What was the best of your recollection of your conversation with him regarding paternity of the youngest child?
When I spoke to Austin, he does not believe he is the father of the youngest child. I did state if DNA were to establish that you were with the father, would you have any wants or needs to be involved with the youngest child? And he denied that he would want to be involved whatsoever with the youngest child if DNA were to establish him as the father, which he believes he is not the father.
And if this court orders the removal of the youngest child, do you happen to know who the foster care agency will be on that component?
It will be with the department.
Okay,
The foster
thank you.
workers.
And do you know who who is the foster care worker?
Eva Copus.
Okay, thank you so much for that. Your Honor, I have no further questions of Ms. Miles and believe that's sufficient to establish the factual basis for the petition. The no contest plea, I'm sorry.
Okay, Cross?
Just one question. You were present when I had a conversation with Ms. Copus, and she's going to be zooming in with my client to establish a case service plan, correct?
Yes, that's correct.
Okay, nothing further, Your Honor.
Ms. Heiss, any questions?
No questions. Thank you.
I have a couple, sorry. All right, so when was the drug raid?
The drug raid, I'm not sure of the specific date. I know that it was on Tuesday, but I apologize. I
Like
don't-
last Tuesday?
Not last Tuesday, but the Tuesday prior.
So just a couple weeks ago?
Yes,
Okay.
yeah, recent.
Do you know if the domestic violence between her and her mom is the only criminal matter that she has outstanding?
There is a detective that submitted a request for charges for cybercrime and requested an arrest warrant. But to my knowledge, that has not been approved by the prosecuting attorney's office at this point.
All right. Are you gonna be our foster care caseworker moving forward?
I will not. Eva Copus will be.
Okay, all right, Ms. Combus. Yeah, so she probably won't, she's met me a few more times than you have. She's not gonna be surprised to hear me ask for a register of action for any criminal cases moving forward. So we can keep up to date on what's happening with those. Now, I saw in here that there was a singular drug test in January. Is that the only one?
Yes, I did ask for a drug test on Friday, but she denied to submit to that.
All right, so what are your other concerns that indicate to you that her use of drugs is getting in the way of her parenting?
So my concern is that when she chooses to do the drugs and the illegal substances, she leaves for a long period of times. Where Dawn, I had actually spoke to her on February 9th over the phone. Her mother, Dawn, had indicated that she has done this before and that she had actually disappeared from December 2023 approximately to the beginning of January, where she was left with the children again with no legal means to provide and take care of Briella.
Questions based on my questions, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
No, thank you.
Ms. Heiss?
No questions.
All right, thank you for your testimony. You may return to your seat. All right, attorneys, are you satisfied with the advice of rights and the factual basis of the plea?
Yes.
I am.
I am, Your Honor.
Very good. The court is also satisfied that the plea was knowingly, understandably, and voluntarily made, the full understanding of the potential consequences, and also that the record supports that one or more of the statutory grounds alleged in the petition are true by a preponderance of the evidence, requiring the court to authorize the petition. And I also believe, well, I'm going to also find that the conditions for removal are present in this case, but the statutory provisions that have been violated are based on the drug usage that causes Ms. Boker to leave the home frequently. She was found at a rather serious drug raid, and those things were occurring rather than allowing her to parent. She was relying on her mother without giving her mother any kind of legal authority to do that. She would need a power of attorney or a guardianship or something else in order to really legally provide for these children. So I do find that she's not providing proper care or custody. And also by way of the drug usage, frequenting the home where the drug raid occurred and otherwise being homeless also causes a problem with the environment, characterizing it with neglect and drug use, which is illegal conduct. We also have the potential pending requested charges for the cybercrime, which demonstrates that that home or environment created by mom right now is unsafe for the children to live in. She's clearly incarcerated at the moment for a violation of the no contact between her mother and herself, which also indicates that her presence in the home could also result in domestic violence. She's charged with that right now, all of which also provides a significant risk of harm to the children. Also find that this causes a risk of harm to the mental well-being of both of the children as well. So for those reasons, the petition will be authorized, and I will also award the temporary placement of the children to the Department of Health and Human Services, understanding that the plan is for them to continue to reside with their grandmother, with a plan in place for Mr. Fox to provide in large part for the daily care, and to allow Mr. Bellacino to decide if he wants to exercise his parental rights, establish himself as a legal father, establish a relationship with the child, and we'll ask the department to continually actively monitor that situation to put a plan in place that provides both for the short term and potentially for the long term care of these children. Custody of the child with any of these children, but the mother at this point, the only respondent parent, does present a substantial risk of harm to the child's life, physical health, and mental well-being. As it relates to the fathers, Mr. Fox is not able to care for the children at night, and there is a good plan for him to be very actively involved with them, but in order to ensure that they are cared for continuously, as well as Mr. Bellacino's child, it is necessary to allow the department to control placement right now. So that speaks to the findings in 2B and supports the court's finding that there is no provision of service or other arrangement except removal reasonably available to adequately safeguard these children from the risks of harm that I have previously described. For those same reasons, continuing the child's residence in the home of the mother would be contrary to their welfare, as well as with the either father at this time. Consistent with the circumstances, I do find reasonable efforts were made to prevent or eliminate the need for removal. That was the investigation conducted spearheaded by, of course, it's Ms. Miles, right? Yes. Okay. By Ms. Miles, her securing those drug tests and attempting to talk with Ms. Boker about housing and help her make alternative plans to tackle the issues of substance usage that are interfering with her parenting, as well as housing, certainly constitute reasonable efforts. Tackling, understanding what the criminal charges are also constitutes reasonable efforts, as well as safety planning with the grandmother and both of the fathers in cooperation with Ms. Copas and Trump. So thank you for those efforts. As of this time, it is contrary for the children to remain in the home of their mother or either father for reasons articulated by the court. And unless there's any questions, that'll be all for today. As far as the court's proceedings go, our next stage of proceedings is the disposition. So between now and then, as Mr. McFarland noted, Ms. Copas will be reaching out to work with Ms. Boker to develop a plan to tackle the issues that came up today, which include that homelessness, substance use, criminality. So a lot of those things will be tackled by psychological evaluation, individual counseling classes, parenting education, referrals for things like housing, employment, and of course, continuing to monitor those criminal proceedings. And I can give you a date for disposition.
When appropriate, I have one question, Your Honor.
Go ahead.
My client may make bond. If that's the case, will she be allowed parenting time? And will that be typically the norm, the 3 times per week, 2 hours per visit? supervised.
Have a position on that, Ms. Thomas?
You would ask that parenting time remains supervised by the department or its designee per policy standards. I think it's hard to commit to the 6 hours a week with our limited resources right now, but the department does do a very good job of really encouraging liberal parenting time to the extent possible.
Your position, Ms. Heiss?
Well, we have to remember there's a no contact, presumably bond condition upon release. So the logistics need to be worked out, but the children are entitled to visits with mother supervised until and unless the risk of harm is posed, new risk of harm is posed. So as much as liberal as possible, these children are too young. I would like to see a trauma screen, but too young probably for trauma assessment. But at this preliminary stage, the supervised visit is my recommendation.
Any further comments?
I just think because the goal is reunification, it should be as liberal as possible. I know this court standard has been, if we can accommodate it, 3 times per week at 2 hours per visit.
Thank you, Mr. McFarland. I do think that in these particular circumstances, we have a bit of an issue with that, given the no contact between the mom and the grandmother. So I will authorize supervised visits with the department twice a week for no less than 2 hours at a time. As a compromise, I think it's 1 hour at a time is what's typically there. But of course, that will require Ms. Boker to come to the table as well and be forthcoming about her need for transportation, give us our best efforts in making it to visitation, because of course, the order extends to both the parent as well as the department. So if she's not able to make those visits, she'll need to make every effort to do that or to have an explanation for it at the next juncture when we return. All right. DNA testing will be in the order as well. We'll look for the foster care caseworker to make sure that that referral is done and/or exploration of that AOP with Mr. Ballacino, as well as monitoring the progress Mr. Fox is making on his custody case. I can put you in front of the referee for the initial disposition on Thursday, March 14th at 9, if that works.
No objections, Your Honor.
Sounds good.
That works for me too, Your Honor.
All right, very good. Well, that will be your next court date. Ms. Boker, Ms. Kopis will be reaching out in the meantime to accomplish many of the things that we've asked her to, and as well as her many other obligations in that role. Unless there's any questions, that's all for today.
Thank you.
March. All right, we are on record for looks like our first regular review. May I have the names of our participants, please?
Lee Heiss, lawyer, guardian ad litem.
Ms. Saja Thomas, counsel for the department. Ms. Kopis.
Eva Kopis, child welfare specialist with Lenawee County DHS.
Michael McFarland, representing mother who is not in the hall. I do not believe she's on Zoom either, Your Honor.
She is not, I don't see her.
Worker does have an update on that.
Thank you. What about, all of the other parents and non-respondents? All right.
Are here, however, Your Honor.
What?
The non-respondent parents are here, however.
Oh, good. Welcome. Very good. Ms. Thomas, would you like to address with your caseworker first the location question of Ms. Boker?
Yeah, Your Honor, if Ms. Kopis can be sworn in, please. Ms. Kopis, have you had contact with Ms. Boker this reporting period?
Yeah.
And was she informed of today's hearing?
She was. She also had a criminal hearing today at 10 o'clock this morning, in which I had contact with her to attempt to get her to that hearing as well. So she was well aware as of early this morning and previous that she had a hearing today at 2, as well as the morning hearing, but she did not attend.
Okay, do you know where she currently is?
I do not. She did indicate to me approximately half hour ago that she was coming. I apologize, she's not here.
And have you heard from her since that last communication a half hour ago?
I have not.
Okay. Has Ms. Boker been incarcerated at all this reporting period?
She has.
Was there any like substance abuse treatment that she engaged in, whether rehab or inpatient treatment?
So I did complete the initial intake with mom through CMH to get her into substance abuse treatment. She was then assigned to Parkside. My understanding is that she did complete her 48-hour intake approximately on April 15th. I know that she's had appointments scheduled since then, but according to her primary counselor, Chris, she has not attended those appointments.
So there's not a chance that she's like at a rehab facility at this moment.
I do not believe so, no.
Okay. Your Honor, as relates to Ms. Boker's whereabouts, I have no further questions for Ms. Kopis, but we'll obviously have more questions as relates to the court report whenever the court is ready.
All right, Ms. Heiss, would you like to defer on your report until after that, or would you like to report now?
After, I think. Thank you.
All right, Ms. Thomas, you may continue whenever you're ready.
Thank you. Ms. Kopis, as it relates to Ms. Boker, how would you describe her level of compliance with and benefit from her case service plan this review period?
Overall, Ms. Boker is in poor compliance with her case service plan.
It looks like she's not doing that great at keeping you updated, I guess, on any services or anything that she is doing.
She has not. She has kept in sporadic communication with the department. She does communicate when it benefits her. However, if I'm seeking her for information, that could take a while to get a hold of, depending on the circumstances.
In your report, these there's some criminal cases that are under the component of the case service plan regarding law enforcement. Are those additional charges that she has picked up this review period?
She has picked up 2 additional charges. My understanding is she got resisting arrest at her last time she had contact with law enforcement, and I do believe that they were filed as felonies.
And she's not complying with her terms of probation. Is that still accurate?
As of this morning, she had formally violated 4 times, including having contact with protected parties and not drug screening for the court.
From Parkside, you said that she did her intake, but have you received any updates on any progress? I'm sorry, if you can just repeat that portion.
Yeah, my understanding is that she did complete her 48-hour intake approximately on April 15th. She has scheduled appointments with Chris, who's her main contact through Parkside. However, those appointments have not been kept for various reasons, including her being arrested.
Okay. Let's see, parent education. How that looks like it was terminated through Orchards.
Yes, so she was originally referred for the Orchards family program for parenting education. It took approximately 3 weeks for her to get engaged and initiate that service. And once it was initiated, she was arrested, and that caused the referral to be terminated.
If she's able to take care of her and outstanding warrants and whatnot, is that a service that could be re-referred for?
Absolutely, we're in the process of re-referring for that program. It does appear that there might be a wait list for that program. So we are doing our best to get her back in. We'll be looking for other sources of parenting education in the meantime.
And it looks like mom's doing pretty good at attending parenting time, though. Is that correct?
Initially, when this case first started, mother did very well with her parenting time. She was very engaging, very one-on-one with the kids, very present for those parenting times. Recently, we've seen that kind of dwindle, where I'm not seeing her participating in as much, and we're seeing a lot of missed parenting time, mostly citing that she's sick or incarcerated.
And the drug screens that you've included are positive for, one was positive for cocaine, the other one positive for THC and cocaine, another one positive for THC and cocaine. Are there any negatives that you've had from her during this review period?
So she was actually referred for colors and was assigned the color purple and expected to screen once a week. She had not participated in any of those. The screens we do have are when I met with her face to face and asked her for drug screens. She has not complied with her drug screens, nor do I have any negative screens for her.
And the children, it's an interesting setup. Some of the children with Mr. Fox, they're with grandma, but under a power of attorney, correct?
No, my understanding is that all 3 children were placed with grandmother.
Okay. But dad is a non-respondent.
Yes,
Okay. And is the placement still working out okay for this family?
it is. The family has actually been able to come together, both punitive dad, legal dad, and grandmother for all 3 children's benefit. They have been able to co-parent. They've been able to facilitate things without the department needing to intervene. They've done a fantastic job of ensuring that these kids have built new relationships, but have also maintained old ones.
Wonderful. And then today you've also included the DNA results for Mr. Ballacino as relates to, I believe this is the youngest child, is that correct?
Yes,
Okay. And he is the biological father. Is that how you are interpreting the DNA results?
yes,
And did you discuss those results with him?
I have.
Okay. And is he receiving parenting time with his child?
He is. He started parenting time approximately on May 6th, right after we had a delay in getting the results to us. And so he's been visiting 2 to 3 times a week. Since then, we started initiating overnights, and they have been going more. My understanding that he is actually at the home quite frequently, more than the 2 or 3 times a week, depending on how his work schedule is.
And the other children, the older ones, are they getting overnights with their father?
Mr. Fox also visits the home every day regularly to ensure that children are being cared for, as well as he also takes them on weekends.
Okay. And this arrangement, like you said, that's working out fine for the family?
It is, although we do ask that Austin be made the legal dad for Briella.
All right, thank you. Is there any other updates that you would like to provide the court as relates to the children?
Not as it relates to the children, no.
For reasonable efforts component, what reasonable efforts have been made to help mom with, I guess, gaining some traction on her case service plan?
We've provided transportation to and from services. We've offered transportation to and from services. We recently, as of last week, have introduced Linda Edwards as the supervisor specialist to assist with the parenting time. The goal moving forward is, as of right now, the children visit twice a week for 2 hours with mom. That seems to take up quite a bit of her time with Brody. And so we're trying to add a 3rd visit that would allow mom to have one-on-one time with kids. So 2 visits with all kids and 1 visit without. In addition to actually taking her to services, we have not with all the services we provided for her at this time.
Thank you for that information, Ms. Kopis. Your Honor, with that, I have no further questions for Ms. Kopis and move to admit the court report with its attachments.
Objections? I have none.
No position without a client.
All right, they are received. Cross-examination, Mr. McFarland?
No, Your Honor. Well, I do have one question, yes. Did my client indicate where she was when she called you, indicating that she would be here?
She did not. I made the assumption that she was staying with a friend, Kyle, because that is the last address I've known for her. But she has been transient this reporting period and has not stayed in one place very long.
Thank you. Nothing further.
Your court report says that Mr. Ballacino has a custody attorney, is that right?
Is my understanding, yes.
Have you talked to that person about a custody order for his child, Briella?
I have talked to Austin himself. I've not spoken with his attorney. He did let me know prior to hiring an attorney that he would be doing so, and so I ensured that he had everything that he needed from our foster care case file.
Am I right that in the police report, the mother was found at Mr. Fox's house when she was taken in for a warrant?
Yes.
What's the nature of that? Have you interviewed anybody to know why she was there?
She said that it appears as though, in between some of her stays, she may have been staying at Mr. Fox's home when the children were not there. And it appears as though she came back to the home knowing that the children were there because she didn't have anywhere to stay and felt the need that she could stay there despite the fact that the children were there.
Have you had any evidence that the children see their mom through Mr. Fox?
I have not.
And are all three children going to have basically daycare with grandmother, maternal grandmother?
As of right now, that is the tentative plan for grandma to be the primary child care. She'll also be the one transporting to and from parenting time.
Okay, and then we'll see what happens by the time school year comes.
Yes.
And are you scheduling a family team meeting about the older two children and their placement?
We actually have a family team meeting scheduled for today at 3:30 to discuss that placement.
Okay. Is it on Teams?
It's in person or on Teams.
Because you know I can't do Teams, right? We've discussed this.
I'm aware of your struggles.
Thank you. Because there was an FTM in this case wherein it was decided that the little girl is going to, with the judge's permission, if she's if her father is declared to be her paternal legal father today, she might be placed with him as soon as today.
Yes, that is the plan.
But the older two children, that family team meeting will be today at 3:30. Thank you. How long was mom incarcerated for this warrant that they picked her up on?
She's never spent more than a week. And I apologize. As of this morning, when she did not appear for her court hearing, there's another bench warrant issued for her arrest.
Is anybody posting bail for her?
My understanding is the friend Kyle that she is staying with.
Okay. One more question. Just a minute here. Okay, I can't think of it. Thank you. I have nothing further.
Redirect, Ms. Thomas?
No, Your Honor.
Today was scheduled for a permanency planning hearing as well. For the oldest two children, does it look like the best arrangement for the family is going to be to stay with grandma?
I believe that the best arrangement is going to be with dad. He has the supports in place to ensure that the kids are being cared for.
Even if mom is residing there?
I do not believe that that is something that is going to continue. In my conversations with Mr. Fox, it did not appear, I think he understood the severity of what had happened, and moving forward, I don't foresee that being an issue.
You don't find it concerning now, given that the allegations were pretty open about what's been happening with her, that he would ask her into the house at this point?
I have concerns that he allowed her into the home. I believe that he can still keep the kids safe from her. He did so in calling law enforcement when she did come to the home while they were there, and he made sure that the children were never in her presence.
Okay, thank you. Redirect, Ms. Thomas, or questions based on my questions?
No, Your Honor.
Mr. McFarland?
Just one, the family team meeting today at 3 or 3:30, does that involve my client?
She was invited. It was initially scheduled while she was in jail, but I have invited her since then.
And she has the contact information?
Yes. And I apologize. She indicated that she'd be by person because it's my understanding as part of one of her bond conditions, she does not have access to the internet.
Okay, and you'd still encourage her to participate if she showed up, right?
Absolutely.
Nothing further.
Your Honor, not within the scope of your questioning, but I remembered what I was going to ask before. May I?
Yes.
So the drug screens for mother are generally confidential, is that right? So these family members who are trying to support mom or tough love or whatever, they're not aware that as late as May 7th, mom was testing positive for cocaine. Is that right?
They are not aware of that. Obviously, we would not have told them that.
And then in April and several times in March, on all these screens, there's positive for cocaine, right?
Correct.
Thank you. So, thank you, Your Honor, that's all.
Thank you for your testimony. We return your seat. Any other witness testimony today, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
None.
Ms. Heiss?
Your Honor, I have not visited with these children. We, our paths just didn't coordinate, but grandmother has the children during the day and is anticipated that she will, we've communicated several times, and she was here at court this morning. I think she's here today now. It's a remarkable relationship she has with these, the fathers of these kids, and they are really amazing kids. So I look forward to visiting with them and filing my verified statement as soon as I can. Thank you, Your Honor.
Comments in closing, Ms. Thomas?
Thank you, Your Honor. I believe that this court has given the department placement authority through prior court orders, and so we would just ask that continue, but also recognize Mr. Balancino as the legal father. And with that, we would be able to assist the family with transition planning if need be, but we can always change placement as long as we have that authority in the court order. But with that, I think it is really early in the case, and I know that we haven't really touched upon that permanency planning component. I know that mom was given proper notice of that, but given that there are two non-respondent legal fathers in this matter, I think the goal for unification is still appropriate. Mom is in need of some additional assistance in getting kind of back on track with her case service plan, or getting on track to begin with her case service plan. And hopefully, as maybe she gets sober, she'll be back on track with parenting time. But with that, I believe that there's, at least as it relates to the children, a sufficient safeguards for Thelma and their fathers. And we do ask for a 90-day review, pretty much status quo at this time. Thank you.
Mr. McFarland?
No comments.
Ms. Heiss?
Your Honor, I am probably wrong, but if placement were given to the father of the older two, he may choose to put the children back in a guardianship with grandma, a POA with grandma. The relationship is remarkably good because it's so important for grandma to see the children, and the dad comes over like daily when he isn't working. And so I heard your concerns about permanence being finished with custody with the non-respondent fathers, and I think that can be worked out for even next review period. I don't know that that mother will stipulate to custody, but I'm very cooperative family. Thank you.
Thank you. Well, the court finds all interested parties are given notice for purposes of today's review hearing and permanency planning hearing. I'd like to have you explore, as part of your planning today, the idea of potentially a juvenile guardianship to support the family in that, and also to have that structure there so that if something happens and Ms. Boker is back, or other concerns arise, then the department would be able to spring back into action, frankly, which is how those are designed. Plus, they have the additional supports of the funding piece. That would also give Ms. Boker some additional time. It wouldn't require us to terminate her parental rights, and it would allow the family to stabilize in the situation that they're currently in. So please explore that as we come back. I'll set our next review hearing as a review and permanency planning hearing. It does appear that there is no risk of harm associated with allowing the department to place the youngest child with her now legal father, Mr. Austin Balancino. I will reflect in today's court order that DNA has established that legal relationship as well. And I look forward to looking at those custody pleadings. But if you want me to, Ms. Thomas, I can reflect that placement is changed effective today, or you can simply do it under your authority. It's up to you.
Yeah, I think we can just do it under our placing authority. Thank you.
All right. I do find that returning the children to the care of Ms. Heather Boker does present a reasonable risk of harm, and that the arrangements made basically by consent between the other non-responding parent and the grandparent is safe at this time and allows him to maintain his bond with the children and keep keep some boundaries there as well, considering that Ms. Boker is still pushing the boundaries, if you will, as it relates to that relationship with him and around the children. So until she gets used to not being there, I wouldn't want that to be a place where they frequent. Frankly, Ms. Boker is clearly struggling at the moment. She hasn't been able to overcome the challenges presented by some of the substances that she's using. I'm sure that's related to many of the things that were discovered in the psychological evaluation as well, including some past trauma that she needs to address in order to get to where she can address her substance use. She hasn't shown us she's been able to find a place to provide for the children, to provide financially for the children. So many challenges get in the way of us returning the children to Ms. Boker, but I'll need to have the update for sure as it relates to Mr. Fox in the next report period, and whether or not he would need to be named as a respondent, or if there's another resolution to the case that everyone could agree to. All right, our next regular review, I'll schedule up for 3 months. That's into September. We actually might have to back it up just a little bit. Are you all available August 28th in the afternoon beginning at 2:30?
I'm gonna speculate, yes, I don't have my phone.
Yes.
3:30.
Yes, I'm available.
2:30, yes.
All right, so we'll schedule our next review and permanency planning hearing in this case for August 28th at 2:30 p.m. Unless there's any questions, that's all for today. For the initial disposition in this matter, may I have the names of our participants, please?
Lee Heist, lawyer guardian ad litem.
Ms. Daja Thomas, counsel for the department. Ms. Copas.
Eva Copas, child welfare specialist, Illinois County DHS.
Michael McFarland representing mother who is not in the hall. I don't believe she's on Zoom either.
Okay, and I have to correct that. I think our next one's the initial. This is our second regular review. Anyway, thank you. Have you heard from your client at all, Mr. McFarland?
No, speaking to the worker though, I'm told that her intentions may be to turn herself into law enforcement today.
Easy.
That's all I know.
All right. We have 2 non-respondent parents, and I understand maybe there might be one of them here today.
Yes, this is Austin Balagino.
Welcome. All right, Ms. Hines, I look forward to your report.
Thank you, Your Honor. Before I get rambling about these really cool kids, I want to point out the legal parts of my presentation. I believe the department intends to reunify the 2 boys with their dad, who is a non-respondent. The plan would be for dad dad has a custody suit pending. I think he's stuck in that loop again where friend of the court won't let him file. It appears they've had some turnover in staff down there, and this is happening again. I have about 3 cases that I've prepared this week for you that all have experienced that. So, and I am not opposed to that. The plan will be, if he gets custody, because this mom is not progressing, that what's best for these kids is that the children will stay 5 overnights a week with grandma. It's a good situation. She gets them to school. She's very attentive. And then he's there every day from like 5 to 7. And he takes the children on the 2 boys on the weekend. 1 boy is his biologically, 1 we think is not his, but he's treated all 3 of these kids as his kids growing when they were growing up. Oh, this is the grandma. I missed a family team meeting. This grandmother placement hasn't given me access to the children in 2 review periods. So I walked in yesterday unannounced, which I had never done before, and they were very polite, but they're very unhappy with me because the littlest girl went home to her biological legal father after having been raised with this grandmother, and she's very attached to this little one. So I visited all 3 kids face to face. The little girl who went home, the youngest who went home with her father, has a fictive brother in the home. It is a wonderful home. There is a lot of outside area. There's Great Dane and just a lot of, I think a lab too, but anyway, a really healthy home, really working parents, and she has a parent available to her all day, and she's doing really well, bouncing around on the trampoline, and you would really love the environment. The older 2 boys really miss contact with that little girl, so I have a plan for that. So I visited the 2 little boys at grandma's house, and they're upset with me because the little girl went home. The plan was the little girl was gonna do daycare at grandma's because she's grown up there and it's a nice place. It's a loving place. And the relationship broke down. So now dad does his own daycare and the little girl doesn't go there anymore. Grandma's very distraught about that. And the two little boys would like to have more contact with this little girl who's doing so well in her environment. Okay, so the two boys are doing very well. 5 nights a week at grandma's. I think we should continue this. The boy that's in school is doing exceptional. Every day he earns a little ticket for his behavior and his grades. This is placement that just came in.
I'm so sorry. It's okay.
So he's doing very well academically, and this plan works very well for the boys to be with grandma where they've always grown up. And dad, their legal father comes. This is the problem. Okay, so reuniting with dad, he is going to continue the same plan, which is the boys will be with grandma during the week, go home with him. They have a great relationship. What I'm trying to convince grandma of is she shouldn't trade on her relationship only. The legal authority to have those boys there 5 days a week is something that we could do for her through a guardianship or something.
We've agreed to that.
But bio dad has done nothing wrong, so he deserves his kids back. But then he's gonna put them right back with grandma where they belong 5 days a week. And they have a long-term relationship. This bio dad, the dad of the two boys, has lived with grandma more than the mom has lived with grandma. She trusts him, she loves him. So that was the only tweak that I was gonna make. I missed a family team meeting and one review period ago, grandma canceled my visit. This time we weren't having a visit, but then we finally got through and communicated and talked. So that was my only tweak. I told the family I'm not trying to change what they do. I'm just trying to make it a legal structure that it doesn't happen again where she can't babysit because dad says, because the relationship breaks down and he has the youngest girl. Anyway, one last tweak on our proposal. So that I don't think that's really in the case, in the court report. It's not really emphasized under recommendations, but there is a plan to in theory only, reunify the two boys with the dad. I have no objection to that. The dad has a pending custody that's stuck. And, okay, but we'll get more information from the caseworker. She knows more about that. And then the visits that mom misses, like 75, 80% of the visits she misses, what if we were to keep those visits on and the children visit each other there? So with Miss Edwards, it's not whether mom, because I was gonna go observe the boys at mom's visit. And the youngest one, but mom doesn't come, so those visits gets canceled. What if we set those up at least every other one or something for the kids to see each other? They grew up together, and maybe grandma could come into some of those supervised visits because she really was the parent figure, and she's the rock behind the kids being here where we are now. One boy has autism, and you can't really communicate with him, and he walks on his tippy. I mean, he's true, and he cuddles with this grandma. And a lot of times kids don't want that physical attention. You just can't reach him. But he lets her dress him. He lets her touch him. He's very familiar there. So my recommendations are that we work another review period. I have no objection to reunifying with dad because grandma trusts that he's going to leave the kids there. But I think the form of a guardianship, one kind of form would be funded, one kind wouldn't be, and the family says they don't need it to be funded. But I think we should leave this family with grandma having the authority as the rock of the family. Anyway, and it sounds like maybe grandma has dad's permission, and using those visits for the children to see each other at least some of the times when mom cancels. That concludes my remarks.
Thank you. Testimony today, Ms. Thomas?
Your Honor, may I inquire if Ms. Heather Boker has joined us on Zoom?
I think she may have. I know Mr. Anthony Fox has joined us. Are you Heather Boker, ma'am?
Yes, ma'am.
Welcome.
Your Honor, before we move forward, because I do intend to ask if Ms. Boker would like to testify, may I inquire with Mr. McFarland if he would like to break out with his client first before we continue?
Well, if I may just inquire on the record if she wishes to speak to me
Do you feel the need, you need to speak with me first?
Not that I'm aware of.
Okay, I have no objection to her being called.
Thank you. Then I would ask that Ms. Boker be sworn in. Thank you. Ms. Boker, is it okay to refer to you as Ms. Boker, or do you prefer Heather?
You can call me Heather. That's fine.
Okay. Heather, did you have an opportunity to review the court report that was submitted for today's hearing?
I did.
And were there any elements of it that you disagreed with?
If I would like to speak, I have questions about the abuse allegations. I don't really understand that, I guess.
Okay. So that's part of the reason that the children are in care. And so today we only focus on the review period. So the last time we were in court was June 10th. So from June 10th to today, just focusing on the progress.
Okay.
Does that make sense?
Yes, ma'am.
Okay. So generally, the court report indicates that maybe you've been struggling to comply with your case service plan.
Yes, at the beginning I did.
Okay.
Yep. I was very avoidant.
And as it relates to your living arrangement, do you have stable housing at this point in time?
Yes. Yes, ma'am.
Have you communicated that to Ms. Kopis?
Not really. We have not talked much as we used to since Linda's been put on the case.
Okay. And I just am trying to understand, are you stating that you're not talking with Ms. Kopis as much because you're communicating more with Ms. Edwards?
More with Linda lately, yes.
Okay.
I'm sorry, that broke up. I couldn't understand your answer, Ms. Boker.
Yes, I communicate more with Linda lately.
Thank you.
How often are you reaching out to Ms. Kopis?
I talk to her maybe once a week, maybe once every 2 weeks.
Okay. The court report indicates that you have an active bench warrant.
Yes.
As of the last review period. Is that still active?
Yes, ma'am. And I talked to my lawyer yesterday, and Monday I have to go and turn in.
Okay. And was the bench warrant active for failure to appear and failure to comply with maybe probationary terms?
It was bond restrictions.
And currently, is there still the no contact order with your mother, Miss Dawn Gibson?
Yes, ma'am.
Okay. And have you been following that?
Yes, ma'am.
It looks like you completed your psychological evaluation maybe a week or two ago.
It was done on August 10th, I think.
Oh, okay.
Yeah.
I'm sorry, I misread that. As of the report date, the assessment or evaluation had not been submitted. Okay. How are you doing with your substance abuse treatment with Parkside?
I do Zoom. I'm required to do once a week. He received me last week, so I have not seen him.
Okay.
And
can you slow down, please? I'm only getting every other word, so if you could slow down a little bit, I think that could help.
I'm required to meet with him once a week. I have not seen him since last week.
Okay. And have you started meeting with a recovery coach yet, or where is that in your program?
So far, I meet with 2 counselors from the substance abuse treatment plan. So I'm not sure exactly what they are.
Part of the case service plan indicates that you are assigned a color for random drug screening, but you have not participated in that. Can you explain why?
So my bond restrictions are not to be using the internet, and to find out my color, I have to use internet. So Linda has agreed to screen me randomly and when I come in.
Okay. So for LDC, the way you cannot call in to find your color, if whether your color was called?
And not that I have seen. I know I have to through the probation, but I have not got a number through Ava through that service.
Okay. And are you currently employed?
No.
How are you maintaining housing?
Right now I stay with my grandmother and I get help basically from my family until I can get everything taken care of. Because I just currently lost my own place a couple months back. So this is new.
One of the concerns, I don't know if you've caught it or not, but Ms. Heiss had also mentioned the, lack of parenting time that you've attended.
Yes. I've been pretty concerned about the warrant and I'm going to be honest, I've been really scared about going back to jail. So I have been kind of avoidant, honestly.
The department is requesting the court to reduce your parenting time to only once a week scheduled for 2 hours. Do you have an opinion on that?
I mean, I would preferably keep it to 2, but there's not much really I can say.
Okay. And it seems like from the court report that you are also provided transportation to parenting time. So transportation is not a barrier to attending, correct?
No.
Okay. Just double checking on that. Is there anything else that you would like to say for the court at this point in time regarding your case service plan or compliance with it?
I just, I want to apologize to the court and everybody for all this. And I really hope to get my children back into the home with me if possible and complete my services and take care of everything. So that's about it.
Your drugs, I just had one more question regarding your drug screens. They are coming back positive for THC and I'm going to butcher that. Buprenorphine.
No more of that will be in my system. I've cleaned out completely.
Okay. And what is THC not your drug of choice?
I used to have a problem with cocaine.
Okay.
That was what the problem was.
And have you discussed using THC or any other substances with your substance abuse therapist?
They didn't seem to have a big problem with the THC. It was more so the cocaine and the Suboxone. Okay. That was in my system.
The Suboxone was not prescribed?
No, ma'am.
Okay. All right. Thank you. Thank you for your honesty and your testimony today. I have no further questions.
Mr. McGrath?
Just a couple of questions for you. Did you hear the guardian ad litem's report where she's suggesting perhaps a guardianship with grandmother? Did you hear that?
I came in right as you guys were discussing Brody.
Well, the guardian ad litem suggested a possible resolution because grandmother has effectively raised these children for a long time, and the non-respondent father's intentions would be to leave them there, as I understand it. Would be her suggestion be both the parents sign a guardianship, which is a transfer of your parental responsibilities to another adult in her to raise the children. There would still be, visitation and perhaps a support obligation, but as a means of closing this case, a guardianship. Have you had any opportunity to think about that?
Not really, but I'm not opposed to it.
Would you be receptive to perhaps a family team meeting where you meet with the worker and they would discuss what this might look like?
Yes.
Okay. As far as parenting time, once you take care of your bond issue, is there any impediment from you visiting twice a week at the current schedule?
No, not. Like I said, Monday this week I have to take care of it. I just don't know how long they're gonna hold me. So
Sure.
when I talked to Ava, she told me that they will pick up my parenting time after that. So there should be no problems at all with making it.
So would you be able to call, let's say, a day before your visit, confirm that you will or will not show up, so the kids aren't expecting you when you don't show? Would you be able to
Yes.
do that? And you have a telephone that wouldn't be voiding your no internet?
Yeah, I do. I'm allowed
Okay.
to use the internet for my court cases and calls and emails. Anything
Gotcha.
court related.
Isn't drug testing court related or not?
Yeah, I guess. Yeah.
So can you maybe talk to your PO and see about if you can use the internet for the colors, okay?
Okay. Yeah.
Okay.
Yep.
Is there any point or any portion of your case service plan that you think that you need assistance with or having difficulty accomplishing that you could reach out for help?
Not really. I mean, communication with my daughter, but we already have a custody battle established for that. So I don't think so.
Okay. Perhaps the guardian ad litem has some questions for you, but have we concluded everything that you wish to express today?
Yes, sir.
Thank you.
Ms. Hines, any questions for Ms. Boker?
Your current address, is that something that Eva has?
Yeah, I've given her both the address because when I bonded out, I was staying with a friend, but now I'm back staying with my grandmother. So I still have the same address. I was just back and forth through visit days and court dates and stuff in town, but it's still 101.
What city is that?
Brooklyn. It'd
Okay.
be Jackson County, I think.
All right. Some of your transportation to visits is, does Miss Edwards pick you up, Linda?
No. Right now,
How do you get to?
I've been using friends and family to get there.
Does Anthony help you get there sometimes?
He has one time back, but not necessarily because he's at work.
Okay. So on the weeks that you don't see the kids, it looks like you've visited 7 out of 23 opportunities, 7 out of 23 opportunities, something like that. The weeks that you don't see the children, do you call them or have any contact with them?
I am not allowed to call them, is what I was told. And Briella's father has no contact absolutely at all with me. So I don't know how the well-being of my daughter is. I don't know if she's okay. I've not been contacted back with doctor's appointments that I was allowed to go to even. So I really don't know how my daughter is at all.
Do you know when your next custody date is?
It's October 1st.
Okay, and then have you been in domestic violence counseling?
Not yet. I've not been sentenced or anything for my domestic violence charge.
What is your counseling for that you are going to?
I am doing substance abuse counseling right now.
Did you disclose, do you have a prescription for buprenorphine?
No.
You were testing positive for it. How?
Yes.
But you don't have a prescription.
Nope, but I have completely stopped taking those too. I could pass a drug test anytime.
So are you on probation then for this domestic violence where the placement was the victim?
No, ma'am, because I've not been sentenced, so I'm still on just bond restrictions is all I've gotten from court.
So the pending warrant is for not appearing in court on that case?
Yes, ma'am.
And what were you in jail for and you got out in June?
I violated my bond restrictions by having contact with Andrew Jacobs. So they put me back in there.
And do you have a no contact bond with your mom?
Yes.
You don't talk to her by phone?
No, I'm not allowed to. I see her at the visits for a few, but that's it.
Thank you. I have nothing further.
May I ask one follow-up question?
Well, let's find out if Ms. Thomas has any redirect
Oh,
first.
thank you.
I have none, Your Honor.
All right, Mr. Brown.
Have you entered a plea on your domestic violence case? Have you
Yeah.
gone that far? Okay, so right now you're just waiting to be sentenced, is that correct?
Yes.
Is your understanding when you turn yourself in, that's for the violation of the bond and you're going to be sentenced at the same time? Is that your belief?
I'm not honestly sure because they put my court case on pause since I missed. So I really honestly don't know exactly what's going to happen.
Okay. Which judge is this in front of?
Shadler.
Shadler. Okay, thank you. Nothing further.
Any other questions from you, Ms. Heiss?
No, thank you.
Any other witnesses, Ms. Thomas?
Your Honor, I'd just like to have Ms. Copus sworn in to lay foundation for the court report. Ms. Copus, did you author the court report that it's before the court today?
I did.
And are there any updates or modifications that you're aware of that need to be made to it or any of the attachments?
Yes, page 10 in the case service plan, section 3 reads Kayla Walden. It should read Heather Boger.
Where is that?
Page 10, section 3 in the case service plan.
Oh, the case. Any objections?
No objection.
None.
Are there any other updates or modifications?
No.
As relates to, this is a little complicated, I think maybe it's not. As relates to the two boys, their father has never been a respondent in this matter, correct?
Correct.
Was the intention of the department to ever remove them from his care and custody?
No.
Does this department support the relationship and arrangement that Mr. Fox and Ms. Gibson have created?
We do. It's a well thought out plan and it does have the children's best interest at heart.
As Ms. Heiss indicated, practically there would be no change to the children's day-to-day life, correct? If the court were to legally return the children to Mr. Fox care and custody?
Correct.
What changes does that order create in general, though?
So for the children, it means more contact with dad. So it means that instead of working with the caregiver, I would be working more one-on-one with dad to ensure that the kids' needs are being met. But ultimately, it would mean that they are placed with dad and that he has the authority for treatment, anything educational, of legal matters. He has the authority to care for his children. And during this reporting period, and really since the onset of the case, he has demonstrated that ability. Mr. Fox sees his children every day. As soon as he leaves work, he is at Ms. Gibson's home, caring for the children, providing for them, bathing them, dinners, things of that nature. If he needs to be at an IEP meeting or a medical appointment, he is there. He ensures that if he's not there, that the caregiver has what she needs. And so for all intents and purposes, outside of allowing them to remain with Ms. Gibson for school, he is caring and taking care of his children.
You heard Ms. Heiss's remarks about sibling visits. Do you have an opinion or a recommendation on how to encourage the sibling bond with these two different households?
I mean, we keep to our monthly sibling visitation, which is per policy. We have attempted to coordinate family team meetings to facilitate additional contact between the siblings and the family. My concern about adding additional parent or additional sibling visits is that if this is not how the family intends to maintain after us, I fear that we might be setting the children up for failure, that they're going to remain having this contact when that is maybe not the intention of the caregivers. I don't know at this point how to encourage contact, other than that, what we already have done, and that the family are taking care of the children's needs at this time.
A lot of Miss Heiss, her comments regarding this relationship between Miss Gibson and the little girl really focused on Miss Gibson being, her primary caregiver for a significant amount of time. Have you seen any concerns from the child for not having that consistent contact with grandma or not seeing her siblings regularly?
The only time it's being reported to me or that we're seeing it is when she is actually seeing them. So in those transition periods during parenting time, we are seeing where she will seek out grandma over mom, or she'll seek out her siblings to be in contact with them. But during her day-to-day routine, she is not seeking them out. She continues to do well in her placement, and she is not asking for them.
Thank you. And just briefly, can you reiterate the substantial risk of harm if the children were to be returned to Ms. Boker's care and custody today?
So if the children were returned to mother, there would still be a significant risk of homelessness, substance abuse, physical neglect, and those continue to be barriers to reunification.
As of today, have you received the psychological evaluation back?
I have not.
Okay. And are you still requesting the court to reduce parenting time to once weekly?
We are.
And that would still require the confirmation ahead of time to ensure parenting time could move forward?
Yes, currently mother confirms by noon the date of her visit with Ms. Edwards to ensure that she will be on time for her visits. Because we have experienced Ms. Boker not showing for visits, and the children do not cope well with mom. If they're told she's going to be there and she's not there, they tend to struggle.
Is there anything that you would like to highlight from the court report that Ms. Boker or Ms. Heiss has not already testified to or brought to the court's attention?
No.
Right. Thank you for your testimony, Your Honor. I have no further questions of this witness. I would move to admit the court report with the attachments.
No objection.
No objection.
Thank you. They're received. Cross-examination. Mr. McCrum.
You heard my client's testimony that the reason she wasn't visiting was because she's afraid she's going to get picked up on a warrant. She's turning herself in on Monday. You heard that, correct?
I did.
What are your thoughts about giving her a time frame, let's say like maybe 30 days to have the visitation as you request, and then to expand it if she's demonstrated an ability to keep the parenting time that you're requesting right now?
My concern is that this is a statement I've heard from Ms. Boker before. Ms. Boker has told me a handful of times since June 10th that she would take care of her warrant every time there's a reason for not doing it. She was, at my last conversation with her, she was taking care of it this morning and that she would be here in person. And so I worry about her commitment to this case, and I worry about whether she will follow through. And in the meantime, we have missed visits that are impacting the children.
I think maybe there's some presumption on my part that if she turns herself in on the warrant, and if she has jail time, whenever that's done, if she then exercises regular parenting time for a 30-day period after that warrant is taken care of, would you then consider going back to the regular parenting time when she's exhibited parenting time, because the goal is still reunification?
Absolutely, but we can always expand parenting time. It's just we need court permission to reduce parenting time. Expanding it, and when parents are doing well, is always on the table. It's always an option, yes.
So if she does do well, what are your thoughts about how long it would take for her to exhibit consistent parenting time to expand parenting time again?
At this point, I would need a minimum 90 days. This case has been open since February and mother has not been in compliant. And really the only compliance we've seen has been since July. And so we would need to see a significant more period of time of her to engage in her sobriety and in her services.
So you're saying that you believe that one visit per week would promote reunification?
I think it's the best that we can promote reunification and make it attainable for mom, because right now she's not making 2 visits a week. And so I'm worried that that will continue because she is not ensuring all her services are being cared for. She's not in compliance. And so my worry is that we're setting her up for failure by making it so that she has to make these 2 visits and she's not making them. And so I want to pull back a little bit so that things can be a little bit more manageable and under her control so that she can ensure that she's attending all of these appointments.
I suppose her doing a virtual visit would free up some time, wouldn't it?
I'd be happy to do a virtual visit. That would be difficult given the children's ages and Brody's limitations. He is not able to maintain a phone conversation. Also, we would have to figure out the details. So logistically, the caregiver is not to have contact with the mother. So who would be supervising and what that would look like.
So you mean like do closed television at your office?
I don't know what that would look like. I apologize. If that's an option we have, then I would be more than happy to look into it.
Okay, that's all I'm asking, is the expiration of that. Have you talked to the parties other than my client regarding this guardianship proposal that the guardian ad litem has discussed?
I have had conversations. We did have a family team meeting. It is my understanding at that time of our family team meeting that Mr. Fox did not want to give over legal control to Ms. Gibson and wanted his children placed in his care and wanted the plan to proceed as we had planned.
Okay, I have nothing. Well, I do. Prioritization for my client. Turning herself in be the first thing that you would want her to do for a case service plan. Then how does she progress?
Substance abuse was the main reason the children were brought into care. It should be the highest of priorities. I did hear her speak about her barriers with screening. However, that has been reviewed with her and discussed, and options where she gave me options saying that she was instructed that if someone else checked for her, that she would be allowed to use the internet, that if someone else logged in for her, that was not breaking her conditions based on what she told me. She did not bring the issue to me saying that she was unable to gain access to her drug screens. I had to bring the issue to her. And so I worry that should be her priority, is substance abuse. That is the main reason the kids came into care. It hinders all of her other barriers, and it should be substance abuse.
If your attorney does not call Mr. Fox, I intend to do so. And if his thoughts now are he would support a guardianship, would you support having a family team meeting with all parties involved to discuss what that might look like?
I mean, we are always open to having a family team meeting. We want to do what's best for the family, and so absolutely.
If everybody's on board with that, as the guardian ad litem appears to be, would that perhaps be a permanency goal in the future?
The hard part for the department with that being a permanency goal is that dad is a non-respondent. And so the children, we have no reason to keep the children from dad. So yes, he would have to verbally tell us that he does not want his children.
Nothing further.
Yes. I missed that family team meeting. Would you agree?
Yes, ma'am.
And you use Teams, which you know I have an incredibly hard time getting on Teams. I miss most of your family team meetings for that barrier, right?
We do. We do not have full access to Zoom. I believe we are at the free trial. So if any FTM through Zoom would have to be 40 minutes or less. So we do utilize, I generally do a hybrid meeting, which would be in person or through Microsoft Teams.
So the MDHHS can't use FaceTime?
We struggle to use Zoom.
Zoom. You don't use Zoom at MDHHS?
No. I have not. I use it in trainings, but we have not, I don't have access to like have a 2-hour meeting on Zooms.
Have you asked your colleagues if everyone else at the department is using Zoom, because to reinforce that the court uses Zoom and to keep all these folks using Zoom and being fluent with it?
That's not a particular conversation I can have.
Right. So I missed the meeting where you guys discussed that dad has, he's not a respondent and there's no reason to place with him, correct?
There's no reason not to place with him.
Yeah. But he didn't ask for placement until now.
I think like us, he was a bit confused as to why they were removed from his care to begin with.
But in his care has always been with the placement.
And they're comfortable with how things are.
Right. So at the family team meeting that I couldn't get into with my barrier that you're aware of, anybody had understanding of custody and 5 overnights versus 2 overnights? Anybody discuss any of that?
We did not.
Right. So your proposal is to put the children, place them back with dad, who, because it's best for the kids, is going to leave them 5 overnights every week with grandma.
Correct.
And that would stop grandma's funding.
It would.
Right. So grandma, right. Do you think grandma has does she appear to have a lot of assets and access to income?
Under this plan, Mr. Fox would be caring for his children, so I would expect that if grandma had any needs, that he would be meeting those.
So he would pay child support over?
However that would work out, yes.
Or pay for daycare?
Yes.
So one idea is grandma could, if the children were placed back with dad and he does what's right for the kids and leaves them at grandma's, she might be able to qualify for as a daycare provider for those kids and be paid.
If he would have to qualify for services, state of Michigan benefits, in order for that to be an option.
And he works full time.
Correct. So I don't know his income to say with 2 children what that would look like for the state standards. But if he qualified for daycare assistance, then yes, there would be an avenue for us to make grandma that provider to receive income and for taking care of the children.
But at least short term, grandma's going to go without funding because Mr. Fox is going to do the right thing and have the kids there where they're successful and where he's welcome anytime, day or night. And he does exercise visits almost daily.
Correct.
And he takes the kids on the weekend.
Yes, and he's also present for appointments and things of that nature.
And this is an 11-year relationship where grandma and dad have worked this out. This is what's best for the children. So legally, if you put custody with dad and he stops the daycare arrangement, a new girlfriend, a new whatever, grandma, the main provider for these kids, has no recourse as grandma. So are you intending to place the 2 boys with dad in the next 24 hours?
Yes.
And why wasn't that in the court report?
I apologize. I thought it wasn't under the FTM section, so if it's not there, I do apologize. At our FTM, it was decided that we would move them following today's hearing.
Did you provide meeting notes from the FTM to my office?
I have not.
So it's really inconvenient for you that I missed that meeting and that now I have these ideas and we're working them out here when we always work them out at FTMs, right?
That's generally the course of action we take, yes.
Right, and you were aware that I was not having visits with the children at the placement home, right?
It was brought to my attention, yes.
Yeah, and I asked you if the phone number was right and all that kind of stuff.
Yes, ma'am.
And you offered and let me know that the visits were at DHS and I could observe one of those.
Yes.
Are you aware of a new police report regarding grandma being on the property of Mr. Balaschino and being disruptive?
Yes.
All right. Is that in the police report?
I have not. I am aware of the report. It was not in my court report because I had not actually viewed the police report. I apologize. I didn't have a copy of the police report.
So your plan would reunify the children with dad, who knows it's best for the kids to be 5 days, 5 overnights with grandma. And is grandma reacting well to the fact that Briella went in custody with her dad and the daycare situation broke down so she doesn't see that child? Is she doing well about that?
She is not. I will say that in our conversations since the initial removal in June, I've seen improvement. I've seen her be able to work with us and coordinate, but there was a lot of anger. There was a lot of tears over Briella's placement. And when the breakdown between the 2 families happened, there was more. Ms. Gibson did admit to reaching out to dad daily, despite his request for not having contact with her. those seem to have subsided. And then as well as we had the incidents in which grandma showed up to the home uninvited and was asked to leave. And then it's my understanding that she also then began banging on the doors and windows.
Okay, so, that the father of the littlest one has, a custody date in this court coming up on October 1st. Is that true?
Yes.
Okay, and he's asking for custody. Okay, just a minute, I lost my train of thought. So one of your reasons for placing the two boys with dad isn't that anything overnights are gonna change. You're not trying to do that, right?
No, we're not trying to change the day-to-day routine, no.
So you said that you're going to, but the change would allow dad to access more services.
Yes.
Well, are there services available for grandma for counseling to be emotionally stable while she is the placement?
We would have to go through her insurance and we could help her, I could help her find those services.
Looks like she needs it, would you agree? We've got two kids staying there. There was a real steep precipice, a real sudden drop off in the boys seeing the little girl and grandma seeing the little girl, and they've been together their whole lives, right?
Yes.
Okay, so could, on the days that Miss Boker misses her visits, could the kids still come and see each other, supervised by Miss Edwards, once a month?
We do not have an issue with that, and I would approve of that plan. My concern is moving forward. If we are fostering relationships, we need to ensure that those relationships are going to be maintained. So I think that would involve having a very collaborative FTM to discuss the details of what that would look like. Because my worry is that we'll have that drop off again if the families aren't committed to keeping that. If we're only doing those visitations by Ms. Edwards or with the department, what's the guarantee that they're going to maintain contact at case closure? And I don't want to set the children again up for failure of believing that they're going to see a sibling and they're not. And so I think it would just need to be well planned out.
Okay, and then Ms. Boker has lots of criminal cases open, a felony and two misdemeanors, or 3 or something.
Last I understood, she had the domestic violence charge. She had 4 counts of something to do with disseminating sexually explicit material. And then she had a felony resisting arrest. That was the last I was aware for criminal history.
So she's had a felony resisting arrest in June of this year.
Yes.
Okay, so she's got lots of criminal stuff going on, and right now her current status is warrant.
Yes.
I don't know the whole story. I just wanted your summary of Mr. Balaschino and his live together partner. Is that right? She's a live together partner, not married. Okay. They have decided to not have the youngest girl in daycare with grandma.
Yes.
Do you support that?
I support that because it is dad's decisions to make for his child. There were behaviors that he was concerned about. That I think any parent, he has the right to have those concerns and make those decisions.
Okay. Okay. Do you have any information about Anthony, the father of the 2 boys, and mom being in a relationship where he helps her with transportation or more or less?
Minimal help, but he has been honest and open with that. If he's providing her transportation, I know he drove her home from a visitation. He informs me of that. He's usually pretty good about ensuring that the children, any help that he's giving, that she wouldn't have direct contact with the kids. The kids are always with grandma or elsewhere. So he's not placing them at risk of anything.
Thank you. Nothing further.
All right, I think we're going to take a brief recess. We've got 11 o'clock. That sounds like we have a couple more witnesses for this case. So I appreciate your patience. We're going to take up our other case for this morning, and then we'll come back to this one so that we don't have to rush. All right, we're back. We've got all of our same parties and attendees. Thank you. I'm looking forward to additional testimony. Are we finished with all our questions for the caseworker, counselors?
No.
I am.
Oh. Okay, all right. Come on back up to our stand. I'll just remind you that you remain under oath.
think Ms. Heiss has advised you that the mechanism that's not Zoom that you use for your team meetings is not something that's supported by the county laptops that the public defenders have. I think she's told you that, correct?
I was not aware of the exact details, but I know that it's been a struggle for her to even log into that system.
Well, that'd be me too, because I'm also counting. Question is, couldn't you schedule 3 back-to-back Zoom meetings in which if one elapses, then you just pick it back up and you continue where you left off on Zoom?
I think these meetings have been made to be hybrid as well. I think if the technology can't be used, then in person might be best. I think that would cause a lot of confusion to go back and forth to getting in and out of meetings when we already struggle with technology. But I would not be opposed to it if it worked better for others. I just don't know logistically how well that would work out.
Now everybody's appearing on Zoom here, correct?
Yes.
And we've had a break and we're resuming again, right?
And we've also had issues where people couldn't be heard. So I think it's the technology, but.
So the
definitely
question is, would you be willing to reschedule a family team meeting in which Ms. Heiss and I can appear either in person or maybe the best way for us to do that, so we can discuss progression on this case, apparently whether guardianship or not, so we don't use time here discussing what we could perhaps do in a family team meeting. What were your thoughts beyond that?
I mean, the department is always open for a family team meeting. Those are where our best discussions happen.
Sure.
So if this is the preferred method, then we will do our best to accommodate.
Okay, nothing further.
Ms. Copus, who is your supervisor?
Erica Martin.
Okay. Ms. Marvin, I know she was with us earlier. Oh, she's not here anymore. Ms. Thomas, would you be willing to reach out to her and find out what she could do to help support Ms. Copus? I mean, obviously, there's no question that we have plenty of DHHS representatives that log in for long periods of time. And obviously, this is a barrier that is one that seems solvable. Would you be willing to assist with that?
I can, Your Honor, but Teams is the most productive manner for our internal team. It also allows for the ongoing presentation of the meeting without having to stop through Zoom. The department does not have a membership for all of its workers. There are several options, just as with Zoom. You can call in to a phone number that's provided, enter a meeting ID as provided. You can use a web browser. You do not need to have an app. So I don't know why there's time being taken on the record to discuss this issue when we email regularly back and forth nearly every day about every case. There's never been a complaint posed to me about the way that we're meeting. And if maybe the public defender's office can be the one to purchase Zoom so that we can work on that together and they can set up the meetings. But otherwise, that's where we are. I can talk with the department about it, but Teams does have all of the same features as Zoom.
Ms. Heiss, do you find this to be a barrier in other cases?
No.
So that's the main reason, Ms. Thomas. It appears to only be present in this particular case.
This worker, we have other cases together. The fact that it's the most convenient for inside the office, this whole system is set up for folks outside of the system. And I've articulated this barrier in the past, and it's just a way that I can't participate when I want to.
It also seems to me that asking parents and parties to learn 2 separate systems creates an unnecessary barrier to participation as well.
So when we all use Zoom for free, there's a 40-minute stop. And then at 40 minutes, we're cut off in the middle of our conversation. Everybody has to dial back in. It is, but I cannot imagine a Zoom subscription would be very expensive for the department, but I like the family members to continue to use Zoom and get all that going so they can participate here. But we can definitely work on this. I've called IT for myself to get Teams through the county practices. It just isn't good yet.
All right. Well, I hear you both. And obviously I'm concerned. I want our attorneys to be able to participate, but I'm also concerned that it could be construed as a barrier to parents as well. And obviously we don't want that. We don't want any barriers from the department for participation. They've got enough challenges ahead of them on their own case services. So I appreciate you all working cooperatively on this to move forward in a way that will be effective for. All right. Any more questions for Ms. Copus?
No.
Ms.
No, thank you.
Ms. Thomas?
No, Your Honor.
Thank you for your testimony. We return to your seat. Any other testimony today, Ms. Thomas?
No, Judge.
Mr. McFarland?
Just an inquiry to the court. If the court is inclined to maybe have another meeting on permanency planning through a family team meeting, then no, I have no further questions, Your Honor.
I am not opposed to that. Any objections, Ms. Thomas?
I'm sorry, Your Honor. The question is if we're going to continue to have this conversation about a guardianship.
So at the last hearing, the FTM was ordered to explore permanency to include a juvenile guardianship for the older two children. And I was also looking for a custody update, which I've had the custody update, and I appreciate that, Ms. Copas. But also I learned that the FTM was unsuccessful because of some of the barriers that we talked about on the record. And so I would be inclined to ask again for that FTM to be explored. Obviously, the family members have spoken up as well. I've heard a little bit, even out of turn, that the juvenile guardianship might still be something they want to talk about. And frankly, I do think that that would be an appropriate conversation to have in a family team meeting, rather than trying to explore all these things on the record in the structure, under the structure that we have to abide by in the courtroom. And also to save everyone some time from being in the courtroom and having to be constrained in that conversation about that issue. So, long and the short of it is, Mr. McFarland is confirming that he's going to be asking for that FTM. Is that right, Mr. McFarland?
That's correct, Your Honor, rather than as a court elaborated proceeding here.
All right, so yes.
Your Honor, the problem, I'm sorry to interrupt, but the problem I have with that is that Ms. Heiss and I are the only attorneys who ever participate in family team meetings. I don't know if there's a billing issue with the public defender's office, but for us to have to reschedule that because Mr. McFarland wants it, I find it disingenuous because he doesn't participate in them. If the parents have spoken, and if the legal fathers who have legal rights to their children have spoken about their desires, I don't know that there's a continued need to have this conversation. I understand the court thinks that it would be appropriate to explore it further. But in my argument, I just intend to rely on non-respondent parents. I think it's an overreach for the state to become involved when there are non-respondent parents who can make those decisions for their children. And the court does have the ancillary jurisdiction in the custody matter. So if the court orders it, absolutely we'll comply with it. But I don't, from the department's perspective, I don't see the need for us to, again, go through this process of trying to contact several individuals to schedule something where it's just Ms. Heiss and I who are the attorneys that attend.
Your position, Ms. Heiss.
Well, I don't know what information Mr. Fox got at the FTM about alternative ways. You could have custody, or maybe you could have a funded juvenile guardianship, and maybe these guys would tell me that isn't possible in this family. But I don't know what Mr. Fox has been told, whether this guardianship and the placement was explored. So I do think we need to have another one. I know what Mr. Fox wants at this time, but I don't know that he's been fully informed. And I'd like to do that in a group setting. He doesn't have an attorney, I don't think, in the custody or in the NA case. So back to FTM for me, if you would allow. And it is my fault that I missed the FTM last time, and the department relied on the decisions that were made there. And then I came in later with all this extra ideas, and it has been very inconvenient. I definitely get that.
Well, what I could do is offer you an accelerated review with the opportunity to accomplish that FTM. We could come back as early as October 14th at 10 a.m. I have Tuesday the 15th at 9. And I have Friday the 18th at 10, if you all have any preference.
Tuesday be the preference, Your Honor.
Yes.
Judge, with the ongoing custody cases for both parents being heard before those dates, I guess I'm just wondering what the court envisions happening in those that might influence what happens in our case.
I too look forward to finding out what's going to happen at those hearings. I can't tell you I have a predisposition one way or the other. I have to listen to the proofs and the testimony, and I'll be sure to make sure that those decisions get circulated to interested parties. Does that help?
Sure. I guess I was more wondering if those cases would be adjourned in order for ours to be heard first.
I don't think I see the need for that at this point.
Okay.
They seem
Okay.
to be and they are forms of permanency, right? So, if I hear that motion from one of the parties, when I get there, I'll be happy to listen to that. But also, I don't have any motions to adjourn those. And I appreciate your question, but if you decide you do want to intervene and ask for that, obviously I'd be happy to look at that motion.
Thank you, Judge.
All right,
Those
so
dates again?
it looks, well, Mr. McFarland has voted for October 15th, if you will. Now, I see on my calendar that it looks like y'all have a potentially, or at least some of you have to be in Judge Anselm's courtroom on that day at 8.
Let's take a look.
I don't think Mr. McFarland does, but I see maybe Ms. Heiss might be committed to that.
Maybe, I don't have my calendar updated to reflect that, but that doesn't mean it's not there.
Okay, we just try to keep track of that so we don't double book you. So with that in mind, rather than having that issue, can I offer to you Monday, October 14th at 10? Or 10:15?
Judge, is the court open that day?
I believe so. And for now, I mean, we can go to Friday, the 18th, if you're worried about it, but I think that's Columbus Day. I don't think so.
Yeah. Okay. Then that's fine. Just as long as everyone's working.
I'll be here. Okay, October 14th then at 10? Or 10:15, it'll be 10:15, but I'll just play it.
Will you rule on placement change today?
Well, I can do that. We've established we're gonna do an updated permanency planning meeting, and I am gonna ask you to do that meeting and an updated review hearing and permanency planning hearing. And I'm happy to listen to any additional testimony or argument on the request for placement change. I guess I didn't realize that was happening.
Yeah, and they're gonna lose funding because grandma won't be a foster care placement, although she'll have the kids 5 nights a week. And we won't have an option for a juvenile guardianship because they'll be in home custody with dad. I just think we should hold off till October 14th and talk this through again to get the most resources for the family.
Ms. Thomas, would you like an opportunity to speak to that?
Your Honor, I don't disagree with Ms. Heiss. And practically, there would be no change for these children. But legally, I'm still concerned that we had an overreach of the government. We don't have adjudication or jurisdiction over Mr. Fox in this matter. The children we at all points in time had asked to be released to him, and it was my fault for not catching that in the order earlier. But it was with our understanding from day one, at least as I remember it, that Mr. Fox was going to continue to utilize grandma's support in helping the children maintain the continuity in their childcare because of his work schedule. So that's my only concern. We have a non-respondent father who does not have representation, and I'm concerned about the infringement on his parental rights at this point in time.
Okay, that's one of the ones where there's a custody issue too, though, right? As I understand it, they haven't had a resolution on the custody issue yet.
Where is that case in the custody?
Custody trial is scheduled for September 23rd.
Okay. Your thoughts, Mr. McFarland?
Well, rather than airing dirty laundry in court, I think we could do it in a family team meeting, which by the way, I have participated in family team meetings. And if my client wishes to participate, she has that opportunity too. Custody still unresolved. How it be resolved, but I think all parties would not hurt, would benefit from discussing these matters. At least my client today expressed, first time I've heard, have been able to address with her the issue of guardianship, which she would like to have explored. So I think acceleration is good with possibility of family team meeting in between.
All right. Well,
the other thought, Your Honor, would be mediation's another way. I'm not sure, but that often provides good results. It's another option that has been utilized successfully, especially when you do not have somebody who has representation for mediation. Just a thought.
I mean, I'm happy to provide the opportunity to utilize one of the mediators that the court has arranged today. Obviously, you have the right to choose your own mediator if you wanted to do that. Do we think that's necessary, Ms. Kopus?
I think mediation could be beneficial. It appears that we are all on different streams right now, and I think it might be nice to have an outside party that could bring us together.
Okay, Ms. Heiss?
Sure, I agree.
Okay, well, Ms. Thomas, I sort of skipped you and went right to Ms. Kopus. Did you want to weigh in on this?
No, I mean, I didn't think we needed it, but if Ms. Kopus agrees that she's the one who has to do the boots on the ground work, so I'll defer to her. And yeah, we can attempt to schedule a mediation.
Very good. All right. So the two main individuals that are willing to do it for what the court will pay them include Phil Schaeffler and the Southeastern Dispute Resolution Services Center. Now, you're able to select your own mediator if you'd like to ask that person to contact the court and to be willing to do it at the court paid rate. I'm always happy to pay that person that, but I don't want to surprise them, considering that our rates, although I appreciate them, are significantly lower than the private sector. So, any thoughts on preference as far as that goes, or do you just want to let me know and then you can bill the court if you need to, and I'll just put in the order that we're able to reimburse for any mediation at court rates?
My thought is I would like to try Southeast Michigan Dispute Resolution Services. They have multiple mediators, be more easy, and flexible for us to get in sooner.
I would agree with that.
I would agree.
Okay, still okay with that, Ms. Thomas?
Oh yeah, yep, thank you.
All right, I'll include that in the order then that the parties have agreed to use SEDRS and that the court will be happy to reimburse for that service at the court rate. And that can be the venue or the vehicle, if you will, for your FTM on these issues. Do you want to make any comments in closing? I think I'll make my decision on the placement issue as part of the closing, since it's something I always have to consider when I'm making my findings. So anything else that you wanted the court to know today, Ms. Thomas? Testimony or comments in closing?
No, Your Honor.
Nothing further.
Nothing further from me.
All right, well, the court finds all interested parties were given notice for purposes of today's review hearing. I suppose our second review in this case to look at Ms. Boker's progress. Unfortunately, there are significant barriers that still exist between Ms. Boker and the reunification between her and her children. That also includes some of the barriers that are getting in the way of her being able to even exercise visitation. So I will go ahead and leave that issue. Frankly, I'm not going to make any changes on that or placement until after your FTM, because I think that those are issues that need to be further explored. As far as sibling visits and the placement of the children, they're all going to remain placed where they are. It is the safest and least restrictive under the circumstances, which would include the youngest child in the care and custody of her father. I'd like to ask Mr. Bellantino to participate in the mediation to look at the issue of sibling visitation moving forward. Mr. Fox as well. I think he's still with us, yes, to participate as well. And we'll circulate the information on how to reach out to SEDRS to schedule for those purposes. But I'd like you to discuss sibling visitation, short-term and long-term, in addition to what the best way to support the family may be moving forward. Understanding that I also appreciate Ms. Thomas's position and that things may be changing very dynamically between now and when we come back. So our next hearing will be Monday, October 14th, commencing at 10:15 in the morning. I've allowed from 10:15 to noon so that we don't have to do any advancing and we can hear any and all issues as necessary. There'll be a review as well as a permanency planning hearing. And the older two children will remain in the care and custody of their grandmother, since that is effectively the person who is still taking care of them, as Ms. Heiss articulated, and she supports that. So, unless there's any questions, that's all for today. I'll cut the order, make sure everybody gets a copy, and we'll see you October 14th at 10:15.
We're off the record. Could you
is our review hearing. And I intend to take the review hearing first, but to continue to take judicial notice of the NA file for purposes of the custody file.
What was the phone number again?
24-0000022
Okay, thank you.
NA.
Yeah. Thanks.
Okay, so Mr. McFarland is not available to us today, having rightfully so asked for an occasional day of vacation. Mr. Fry has graciously agreed to pop in on behalf of Ms. Boker. He's had an opportunity to talk with her as well as the other attorneys and myself just briefly about some of the updates that we all look forward to hearing about today. So that being said, I look forward to your report after appearances.
Lee Heiss, lawyer guardian ad litem.
Ms. Stasia Thomas, counsel for the department. Ms. Kopis.
Eva Kopis, child welfare specialist with Lyman County DHS.
Mr. Fry.
Brian Fry, attorney for Heather Bokar for Michael McFarland.
Thank you. Ms. Boker.
Heather Boker, mother.
Thank you. I think we also have a couple of other non-respondent parents here today. Is that right? Your name?
Awesome. Gotcha.
Okay, Austin Valentino. And then do we have Anthony Fox here?
Yes, ma'am, Anthony Fox.
Thank you. Welcome. All right. Okay. Ms. Heiss.
Thank you, Your Honor. There's also a new putative father in the courtroom too, I think, just for our records to keep track of when he joined us. I have visited with the children face to face and their needs are being met in the current placement. We have a very comprehensive planning time, and we thought we had a resolution that would help the family, but at the end we found out there are new factors that we didn't know about. So I think at this point we would request a review in 90 days. Mother has improved, and for 30 days she has really shown some progress. So in addition to the fact that there isn't a legitimate a way to close on the older two boys, in addition, this gives mom more time to maybe progress towards reunification. I would request that the court release the youngest child from jurisdiction as her custody is sufficient to protect her from any risk of harm. And we have had extensive meetings about continuing the bond between the siblings. That would there'd be a division between the siblings if one were not in jurisdiction, but the other two are. So as a group, I think we're ready to recommend closing the case for the youngest and the only little girl, and ask for a review in 90 days for the older two boys.
Would you recommend that we review the release of that youngest child, which would involve Mr. Valentino, before we move on to the remaining aspects of today's hearing?
Sure. Yeah.
Ms. Thomas, what's your position on that?
Your Honor, we join in with Ms. Heiss and her request to terminate jurisdiction as relates to the youngest child. It is our understanding that Mr. Valentino will continue to be an agreeable individual working with the maternal grandmother to get those kiddos some sibling visits. We had a really good mediation on that point. And so I believe at this point we are ready to release that child from our jurisdiction.
So that was a custody trial wherein the father was awarded full physical, full legal custody with essentially supervised visitation. Mr. Fry, I think this is probably maybe one of the things that you may or may not have been apprised about. Have you had a chance to talk with your client about whether or not she wishes to allow the youngest child to be released from the supervision of the jurisdiction of the court in this case?
That is not something that I had an opportunity to discuss with her, Your Honor.
That's fine. Deputy Agent, you swear in Ms. Heather Boker?
If you remain seated, raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Ms. Boker, obviously you were here for the custody trial, you recall that. Because there is now a custody arrangement in place, it does not appear that we need to have that child as part of these proceedings anymore. Would you agree or disagree with that?
I guess I agree.
All right, very well. I do agree also. There is a custody order in place that safeguards the child and places Mr. Anthony Fox at the, oh no, that's not true. Mr. Austin Valentino at the helm of ensuring that his child remains safe, and he's competent to do that. So I will release the youngest child, BB, born August 29th, 2021, from the jurisdiction of the court. Also releasing Mr. Valentino from being required to be here to make sure that we have updates on his child. So you're welcome to remain, Mr. Valentino, or not remain, whatever your preference is, but I wanted to answer that question for you as soon as possible. All right, Ms. Thomas, where would you like to go next?
Your Honor, just for purposes of expediency, I would ask Ms. Kopis to be sworn in. Thank you, Your Honor. Ms. Kopis, you've prepared a court report for today's hearing. Are there any updates or modifications that need to be made to it?
I was informed this morning that a Blake Lewis contacted the department claiming to be the biological father of Brody. I do recognize that we have a legal father for that child, but I wanted to make the parties aware that that had come forward today.
also just the YouTube component. So is that the youngest child of the two, the younger?
Yes,
Okay.
The youngest or the middle?
the middle, sorry, the
That's
youngest
okay.
would be.
Middle child, youngest of the two boys. Sorry.
Yes, I apologize, the younger of the two boys.
Okay. And okay, thank you for that information. And at this point in time, just for the review, emergency planning and stuff, do you believe that there would still be a risk of harm to the children if they were to be returned to Ms. Boker's care and custody today?
I do.
And what would that risk of harm be?
Harm would be subject to physical and neglect and substance abuse. The barriers that brought the children into care have not been rectified, although mother has made progress with her services, and we do commend her for that.
And at this point in time, I think one of the outstanding issues for the department has been there's effectively been a legal removal from Mr. Fox as relates to his children, correct?
Yes.
And are you still asking that the court legally release them to Mr. Fox under his under the supervision of the department?
Yes. He is a non-respondent, and we do believe that he'd be willing to cooperate with us, but we would ask for it to remain jurisdiction over the children.
Generally speaking, your report indicates that there has been progress made by Ms. Boker as it relates to her case service plan. Is there any area that you believe needs continued progress or more compliance?
Parenting education is due to start shortly, so that needs to be addressed. However, that is not at Ms. Boker's fault as to why that has not been done yet. She was waitlisted. So that is the area that we'll be looking for during the next reporting period to see how well she takes advantage of those services. She does appear to be compliant with substance abuse with her peer coach as well as her counselor. I apologize, they were not part of the court report because they were provided to me afterwards, but she also provided documentation that she has been attending AA and NA meetings. And then she has not been drug screening for the department. However, she has been drug screening for probation, and she did sign a release so that we can exchange those drug screens.
And included in the report is a psychological evaluation. Have you been able to review the results and recommendations with Ms. Boker?
I have been able to review the recommendations with mother. It does appear that the case service plan supports the recommendation. There was one difference, which was it was recommending a psychiatric assessment of mother for possible medications to alleviate mental health symptoms. I have been in communication with Chris from Parkside as well as mother, and we are in the works of getting that appointment scheduled for mother.
And as it relates to parenting time, your report indicates that it's occurring, I believe, 2 evenings a week from 4 to 6 at the department. Is that correct? And is it being supervised by department personnel or by Ms. Edwards, or both?
Currently, it's being supervised by Ms. Linda Edwards. That will be changing once the parenting education program is in place. Ms. Edwards will have 1 day, and the parenting education will do the other visitation to support mom in her education that she's learning.
Okay. Let's see. Are you asking for any changes to the parenting time right now?
No.
Okay. And as far as the children are concerned, they effectively have continued, it seems like they've continued this standard of being at grandma's through the week for school and consistency, and then spending weekends with dad. Is that accurate?
Yes, dad also visits the home during the week as well, and to ensure that he is also taking care of the kids during the week as well.
Okay. One of the things we were charged to do after the last hearing was to have a family team meeting or mediation to discuss the possibility of a guardianship for the 2 boys. And without, breaking the rules of confidentiality for mediation, is guardianship something that the family is willing to consider at this point in time?
It was my understanding at the end of mediation that the family no longer believed that a guardianship was in the children's best interest. And we wanted to allow for more time for mother to complete her services.
Is there anything else you would like to highlight from your court report as it relates to the children, or anything from your knowledge that you believe the court should know?
I apologize. I do believe this is my court report, and if not, I apologize. We do have a pending referral for the second child to see a neurologist at U of M. There was some confusion as to
what contact information was needed for that referral. I have rectified that with the doctor. We are waiting for them to reach out to us.
And is there anything else?
No.
With that, then, Your Honor, I would move to admit the court report with its attachments.
I have no objection.
No objection.
Okay, thank you. They are received, the report as well as the exhibits. Questions for this witness, Mr. Fry?
Yes, how you doing today?
I'm well, thank you.
Good. So have you been monitoring Ms. Bokor during this reporting period?
I apologize. Can you repeat that?
Monitoring Ms. Bokor's progress in her case service plan this reporting period?
Have I been honoring it?
Monitoring.
Oh, I apologize. Yes, I have been monitoring her progress.
Okay. And it sounded like your testimony was that she has been doing well recently. Is that right?
I do believe that, yes, I do believe that she took to heart her recent hearings and has been willing to work with the department more and is compliant with services, yes.
Is she in currently full compliance with her case service plan?
As of right now, she's in compliance, yes.
Okay. What kinds of things are you looking to see her do in the next reporting period?
So the next reporting period, we're going to be looking for her to maintain her sobriety. We'll be looking for the outcome of that psychiatric assessment, and then as well as her parenting education as if she's retaining information and benefiting from services.
Is the goal reunification?
Yes.
So right now, Ms. Bokor has gets to see her children supervised at the department. Is that right?
Yes.
And now you said that the children are during the week are with grandma.
That's their placement, yes.
What was that?
Yes.
Okay. And then the children's father sees them sometimes during the week as well, and then has them on the weekends. Is that right?
Yes.
Okay. Now, is that an appropriate arrangement for the children?
At this time, it is, yes.
Okay. And is there a reason why either Miss Boker's mother or the child's father can't supervise her time?
With regards to the placement, Don Gibson referring, they recently had a domestic violence, which was just dismissed. We have not had time to adequately assess whether the caregiver would be appropriate to supervise. It's definitely something we're willing to explore moving forward, which have not had the opportunity. As far as the father, I have concerns about his ability to separate his own personal relationship with mother and what the children need to be safe.
That domestic violence was dismissed, what, like over a month ago, right?
It was.
Okay, and you still haven't explored that?
Not at this time, no.
When do you plan on doing that?
When the professionals believe that when mother has made enough progress to move forward.
Okay. So, Miss Gibson's appropriate to watch the children, but you can't, have an opinion on whether she can also watch the children when Miss Boker's there as well? Is that what you're saying?
At this time, I believe that Ms. Boker needs a professional setting and more structure in her parenting time with the children.
Has Miss Bokor been compliant with her drug screens?
She has been compliant with her drug screens with probation, yes.
And she hasn't had a violation of probation or anything in the last reporting period? Is that right?
In my understanding, in the last 30 days, she has not, yes.
Okay. Okay, I have nothing further.
Ms. Hicks?
Do you have a safety plan, a written safety plan in place for when these children are placed with the two remaining children are placed with their father? So that we can be sure that there's no risk that he will allow contact between mom and children and that he will continue this daycare schedule with grandma?
It's a safety plan that we verbally have discussed. We have not had a written plan for that.
In the event that we're back and he has allowed contact between the kids and mother or any of the things that we're not expecting, are you willing to look at a writing so that we can hold accountability?
The reason we haven't had it in writing is because we haven't placed the children there yet with him. Upon placing the children there, we would solidify a safety plan and have it signed.
Thank you so much. And then will you be sure that when you're saying the mother is complying with substance use disorder, these positive screens for THC, whose definition of sober are we using? Her counselor, her AA, or hers, or yours? But it needs to be consistent.
My understanding, when my conversations with probation is that they were giving her a grace period to allow marijuana to leave her system, and we were waiting for those screens. Although mother has signed the release just last week, I have not had an opportunity to get those screens yet to see if she is clean fully.
So we're going to use probation's definition of sobriety, which includes no THC. Is that correct?
Correct.
Thank you. Nothing further?
I just want to make sure I understand. So you would like, and I think this is what you asked me last time. So you would like me to release 2 of the children into Anthony Fox's care officially, but practically speaking, they would continue to stay with the grandparents 5 days a week.
They would,
including overnights.
They would.
Okay. Is there a possibility that one of these 2 children is not the child of Mr. Fox?
Yes.
And what is your plan to investigate, clarify, or inquire into that?
It was my understanding that we had a legal father, and that the biological father needed to hire an attorney and to file his own proceedings. We do have a legal father who is very attached and bonded to this child, who has provided and cared for him through all of these years, and I do believe would sufficiently continue to take care of him.
But this is one of the children that's staying with grandparents 5 and 7 days a week, right?
Yes.
Okay. But it's also the child who has the most needs.
Yes.
Quick follow-up redirect, Ms. Thomas?
No, Your Honor.
Mr. Fry?
How old is this child that you're talking about?
7?
He's 5.
He's 5. Thank you.
So the child's too old for the Paternity Act to come into play anyway?
Objection, Your Honor. I
She's
think
not
that's a
an
legal
attorney.
question.
I think she would have told us she doesn't know how to answer that question, Mr. Fry.
That's fine, nothing further.
Okay.
At the time that the affidavit of parentage was signed for this child in question, both the bio mom and bio dad knew it was impossible for them to be, for this Mr. Fox to be the bio dad of this child. Is that what they told you?
Yes, both parents have independently told me that they are aware that the second child is not Mr. Fox's, and that they did so knowing when they signed the affidavit of parentage.
Okay, and then if the judge were to order a DNA test today for Mr. Lewis, if he wants to participate, would you be opposed to that?
We would be happy to cooperate with that.
Thank you, nothing further.
Thank you for your testimony. May you return to your seat.
Thank you.
Your next witness, Ms. Thomas, if any?
I have none, Your Honor.
Mr. Fry?
None, Your Honor.
Ms. Hudson?
No witnesses, thank you.
All right, comments in closing, Ms. Thomas?
Thank you, Your Honor. As you know, our request is to effectively place the 2 children with their legal father, who is a non-respondent, Mr. Fox, under the supervision of the department. Primarily, policy-wise, Mr. Fox was not a respondent parent. And as I was reviewing our records, I don't believe that we had an established custody order at the time that we started these proceedings. And so I believe for those reasons, we had a removal order because custody needed to be established. I believe that that's in the works. Obviously, they have a pending trial. And Mr. Fox has the legal responsibility at this point to ensure that his children remain in a safe environment.
think that the family has been working together to ensure that all of the children's needs are being met. Mr. Fox is very realistic about his work schedule and what that would mean for the children if they were staying the night at his house 7 days a week. Grandma and him seem to have a very good working relationship and are pretty close there. So we are asking the court to consider that. Additionally, as relates to mom, there's been some progress made. Obviously, this review period in the last month or so, which has been wonderful. And we are hopeful that she will continue to make progress towards reunification, pending the outcome of the custody matter. And so we would ask for that 90-day review. At this time, Your Honor, I would leave it to the court's discretion and the recommendation of the LJL regarding DNA testing for the middle child or the younger of the two boys that are still under jurisdiction. The child does have a legal father who has and is continuing to provide for him. And unfortunately, I think, as Mr. Fry was going to point out, the statute of limitations or the how long a parent has to intervene through a ROPA action has passed at this time. And I know that one of the considerations is the bond between the parents there, and this child is very bonded to Mr. Fox. And so I'm not inclined to ask the court to order that DNA testing. But I will, again, obviously respect whatever the court decides on that point. I know that as it relates to parenting time, I know that Mr. Fry may make an argument regarding the supervision and who can supervise. So I want to also point out that the psychological has indicated there's a high risk for continued abuse and neglect of these kiddos until mom has made more progress. And I think that's really relevant here as we determine how to move forward in parenting time. The recommendation is to have structured supervised parenting time. I think that 2 times a week, one by Ms. Edwards and one through the parent education service would be sufficient. And as those services continue to progress and be completed, that we could move into maybe a more familial setting for those kiddos. But again, obviously the domestic violence that was made towards grandma is concerning. And so we just want to ensure that there's stabilization and long-term stabilization on that point before recommending any other supervisors other than professionals. Thank you.
Comments, Mr. Fry?
Yes, Your Honor. So as far as any paternity issues, I don't think the court should act on anything regarding that. As the court's aware, the Revocation of Paternity Act gives a parent until the age of 3 to come forward. We're over double that, it sounds like, at this point. Way outside the time frame allowed by statute. So the court couldn't even change paternity even if they wanted to at this point. So, you know, there's no point in confusing everybody and wasting time with the DNA test at this point, from what I'm hearing. In this case, there's already a legal father who has been, you know, caring for the children and has stepped up for their whole lives, from what I can tell. So on that issue, I think it's already settled. As far as my client, it sounds like she has been doing well in this reporting period. I didn't hear any negatives about her from during the testimony. You know, it sounds like she's doing everything that they are wanting her to do, and you know, the additional piece of this education class, you know, hasn't been available to her yet, but it should be coming available soon, so she'll be able to do that as well. But other than that, you know, it sounds like she's been doing very well. So, you know, hopefully that will continue. We would agree with a review period being scheduled. You know, that does sound appropriate from what I've heard, as the goal it continues to be reunification, which we also support and agree with. However, we would ask for a change in the parenting time. You know, I don't know why a dismissed domestic violence charge is being used as an excuse to prevent my client having her mother do the supervision. It was dismissed, which means, my client wasn't found to have committed that, act. I'm actually familiar with that because I represented her on that case. So, again, it was dismissed. She wasn't guilty of that. That shouldn't be used as a justification, and an assumption made that she actually was guilty, which seems to be what, some people are making at this hearing. To me, it would be appropriate to allow Ms. Gibson to be a supervisor potentially as well as the department, and maybe add another day of supervision where Ms. Gibson can do that, as long as my client continues on the trajectory that she is right now. But again, it was all positives from what I was hearing today. She's in full compliance. That does seem like an appropriate step at this time, is to allow Ms. Gibson to also supervise, maybe additional day for that to happen, so the department can still be involved. Ms. Edwards can still be involved as well. Thank you.
Ms. Heiss, any comments?
Your Honor, yes, I would ask you to consider that the psychological evaluation does recommend that visitation should continue to be structured and supervised by the Department of Health and Human Services or its approved designee. It will be important that she's consistent, maintain appropriate boundaries, and respond empathetically to her children. The court report shows us that she attended like 7 out of 23 visits. I believe this is not an appropriate time to move to unsupervised visits. She's doing well at this point, and we want to continue that. With respect to the second child, the parents are admitting that they created a false narrative ever since the affidavit of parentage, and that they knowingly decided that this child would grow up understanding that these were his parents. The child has a right at this point, because the mother's parenting is in question. We have jurisdiction here. We need to know if this child has Native American history, for example. He has a right to know that. In this case, placing with dad of the older two boys is going to make it so grandma is not the foster parent. She's now the babysitter. So the funding stream will be different. I thought it was beneficial to the family to have an extra stream of income coming in, but the family has met. They've decided that although when the youngest one went home with dad and now she's not in daycare with grandma anymore, there isn't a need to protect the older two, because the legal father of those older two is reliable. So I would ask you to consider that when Heather starts to plan together with Anthony, her low score brings his high score down. So they're expecting to grow their family and expecting to plan together for these children. And because of that, a custody order cannot protect these older two children, as it would be nice to let the family go from jurisdiction. However, I would request another review in 90 days. Thank you.
Thank you. The court finds all interested parties are given notice for purposes of today's review hearing. It's also a permanency planning hearing, given the age of the case, but the goal is reunification that was subject to review today. The court finds that the goal of reunification is appropriate, should remain in place. I also find that it's early for me to release jurisdiction, even though I am going to grant the request to officially place the two younger children with their legal father at this point, Anthony Fox. And I'll address more of that in a moment. But I do find reasonable efforts towards reunification have been made spearheaded by Ms. Kopis, as well as exploration of those permanency planning goals as ordered by the court. So thank you, Ms. Kopis, for spearheading that. Thank you also to Ms. Heiss. You are certainly in satisfaction of your obligations. And I do tend to agree with you. I have a little more flexibility even than the statute allows me, Mr. Fry, in order to move and understand and explore the best interests of children in this case. So I am going to direct the department to offer the DNA testing for the middle child and the potential putative father. And that is because of some of the developments that I've seen here. So I'm also signaling to Mr. Fox and Ms. Boker here that I am very well aware that you're planning together, as sometimes it's described, and that Ms. Boker is still at the beginning of showing us her efforts towards reunification. So if it becomes a situation, frankly, where we have to look at removing from Mr. Fox because Ms. Boker's not making her progress or because Mr. Fox is not able to protect his children, then it's important to have a full understanding of what the options are, especially for the child who is literally at the highest needs of any of them concerned by the court's jurisdiction. So I'm not obviously ordering anything at this point other than just the DNA testing in order to make sure that that's really foreclosing off any potential risk here. Ms. Boker did show us that she's willing to give it a go on the case services, which is great. But the children have been removed from her care since February 20th of 2024. That's a long time when you're all under 10 and they're very little and they need permanency and stability. So we'll continue looking at the case for purposes of permanency and progress as we move forward, even understanding that technically speaking, all three of the children currently concerned by the court's jurisdiction have been reunified. Again, I am releasing the youngest child to the care and custody of Mr. Vallicino. That's reflected in today's court order. The children of Mr. Fox will be released to his care, but under the supervision and jurisdiction of the court moving forward. For the reasons the court's expressed, as well as the testimony and the information in the court report, which documents that although Heather Boker is making some efforts, and we appreciate that, she's still at the outset of those efforts and will need to demonstrate a sustained period of sobriety, dedication to her children's needs over her own challenges. And we're looking for her to continue to stabilize on housing and employment and to show us that period of stability and continued cooperation. That psychiatric piece hopefully will be another support coming in soon, and some parenting education in order to make her the best parent that she could be, even if that means that it's a custody and parenting time arrangement. But again, we're clearly up in the air as far as relationship between Mr. Fox and Ms. Boker, with some developments on that point as well. So that's where the kids will be in the next report period. And we'll come back together to look at this case on January 7th at 2:30 p.m. Thank you again to Mr. Fry for stepping in on behalf of Ms. Boker today. And unless there's any questions, that's all for today. All right, we're on record for a review. May I have the names of our participants, please?
Carson Howard, lawyer, guardian ad litem.
Ms. Taja Thomas, counsel for the department. Ms. Kopis.
Eva Kopis, child welfare specialist with Lebanon County DHS.
Michael McFarland, representing Ms. Boker.
Heather Boker, mother.
We are on for permanency planning review as well. I've just confirmed that. And do we have, is Blake Lewis here? Okay, just checking. No, all right. Well, okay, let's start with our guardian ad litem report.
Your Honor, I was able to meet with the children via Zoom on December 20th, 2024. The oldest child, very happy to meet me and see me. He was playing, I believe, Fortnite was the game he was playing, and we were able to talk about his visits with his mother, which he, stated were going very well, and he was excited. This was prior to Christmas. He was excited to see his mom again on Christmas and, continue to keep visiting with her. The oldest is happy, healthy, and he's reported to be making age-appropriate school progress. During the virtual visit, I was able to observe the younger child. He has, special needs, but grandma has, and he does have a great support system around him between grandma, dad, and mom at his visits is making a lot of progress and being able to care and help him out. During the visit, I observed him watch what his grandma described as how-to videos, which are, I think he was watching how to chairlifts work to get handicapped people into their car. So really interesting and, something that he does enjoy. He seems to be doing really well with his current routine with staying at his grandma's during the week. And his dad comes to pick him up on Fridays. And I don't know if that's changed at all, but he's even so accustomed to it that he said this was a Friday and he was actually waiting for his dad to come pick him up on Friday. So after reviewing the court report, I'm very, pleased to see how the mother is benefiting from the program she's doing. The children seem to really enjoy her and she's making a lot of progress with the visits. And, you know, at this point, I do not believe there's any risk of harm of returning the children to their mother's care. And I would recommend that it's in the best interest for these children, for the court to release jurisdiction of these children.
Yeah. Ms. Thomas?
Thank you, Your Honor. If Ms. Colpus can be sworn in, please.
Not sure what you're saying. Whenever you're ready.
Okay. Thank you. Ms. Colpus, you've prepared a court report for today's hearing, and it includes the report itself, a case service plan, a list of drug screens, the Orchards Family Children Foster Care Visitation Support Program, L&L Parent Aid Observation Logs, the appointment for the youngest child and an alleged biological father, and then your proof of service. Are there any updates or modifications that need to be made to any of those documents that I've just listed?
Yes, I have been in contact with Ms. Booker's probation officer, Cora Gibson, and she did indicate to me that 2 of the screens, I believe they are for the 22nd and 23rd of December. They were initially noted as positives for alcohol and marijuana. One of those screens has been sent for confirmation and was found to not be positive. And the second screen was not labeled correctly and has been removed from her list. So her screens are all clean. She did have a periodic one with the department. I apologize for not attaching that, but that screen was also random and clean.
Okay, thank you for that. And are there any other updates?
Ms. Booker has also provided logs of her AA and NA meetings that I did not attach to the court report, but I do want the court to be aware that she does provide them regularly and the dates are consistent with her attending 2 to 3 times a week NA and AA meetings.
At this point in time, do you believe that there's a risk of harm if the court were to return the children to mom's care and custody today?
I don't. Mother has showed benefit from her services. She continues to do well. Her service providers report that she is gaining knowledge and seems to be benefiting from the services. When I met with her to do her home assessment at the end of December, we went through the court report thoroughly. She had good questions. She understands what is expected of her moving forward, what she needs to do to maintain her own sobriety and mental health, not just for herself, but for her children moving forward. She does have a good family support system in place. They continue to support her. They've always supported her. If anything, we've helped secure boundaries so that they understand like expectations moving forward so that to not end up in a similar situation. But mother has done well this reporting period and the family has done well as well.
I noticed that your recommendation is to maintain jurisdiction on the youngest child. Can you just briefly reiterate why that is the recommendation at this time?
The only reason we had wanted to maintain that was because we had the outstanding DNA testing. It has nothing to do with mother's progress. I believe that she will continue to do well with her children. It was only because of we had that pending DNA testing.
If the court were to terminate jurisdiction on the family today, would any of the services that the family is engaged in end?
To my knowledge, the only service that would end is the L&L Parenting Aid, which was a service we were already planning to slowly pull out of. During the holidays, we had allowed the grandmother to supervise parenting time so the children could have Thanksgiving and Christmas and New Year's, and those appear to have gone well.
Would the department still be able to assist, or I guess I'm guessing the department is paying for the DNA test that was ordered by the court?
It's my knowledge that since that is already referral made and the services is pending, that we would still be able to continue with that.
Okay. Have you spoke with the family about terminating jurisdiction and what that would look like on a day-to-day basis for the family moving forward?
I've spoken with father briefly about that. When we did speak, we had originally spoken regarding Bentley during our home visit and what that looked like and the expectations. And then I've also had that conversation with mother regarding that matter.
Is there anything else from the court report that you would like to highlight for the court today?
I'd like to reiterate this family does work well together. I have seen I've seen Mr. Fox and Ms. Boker co-parent. I've seen them communicate. I have seen progress in that area, and I anticipate that it will continue to grow. They do appear to understand the expectations and what they need to do to keep the kids safe, but also to help mom maintain her sobriety.
If the court were to release jurisdiction of the family, other than the DNA situation, it sounds like that's something you would be agreeable to.
Yes.
Okay. With that, Your Honor, I have no further questions of Ms. Kopis and would move to admit the court report and the attachments.
No objection.
No objection.
Okay, they are received. Questions, Mr. McFarland?
So on the DNA test, the samples have not been taken. You have an appointment scheduled. Is that what I understand?
Yes, I did make some effort to see if the surrounding counties had a sooner appointment, given that that referral was made in October. And unfortunately, I was told they did not.
So even if this court were to close jurisdiction on all the children, that would still proceed, from what I'm hearing. Is that correct?
That is my understanding, yes.
The mom could do a friend of the court request for a paternity or anything else that she might want to do with those results, correct?
Correct.
Or even without those results, she could still go to the friend of the court and they would order a putative father to undergo DNA testing, right?
It would leave the control back in Ms. Boker's hands, yes.
And it sounds as though you're confident that she would proceed on that matter if this case were closed and you were not doing DNA for some reason if that happened. Is that my understanding?
I believe that she would follow through in what she thought was Brody's best interest.
Okay. Nothing further.
Other questions?
No, Your Honor.
Okay. So when did you start on this case? When did you take over? In October?
No. I've had this case the entirety that it's been open since February of 2024.
Okay. It says, okay. So we've got caseworker organization change.
Oh, I apologize. I had a small medical leave in November, and so I was not on this case for 14 days.
Okay, thank you for clarifying. So I'm just looking at my notes from prior hearings, and it looks like, as of September, there were significant concerns about Ms. Boker. You were asking for a reduction in parenting time. She had just accumulated a felony resisting arrest in June, distributing sexually explicit materials. There's still those criminal charges pending?
Those criminal charges are pending, but they are working on them. It's my understanding that she will be entering a plea agreement regarding those and that they will not be resulting in her serving jail time.
Okay. Did she move back in with her mother or her grandmother then?
Maternal grandmother, I believe she calls her Nima, or Mammy, sorry. She moved back into their home following our last hearing. I do believe in my conversations with Ms. Boker that the custody hearing in regards to Briella was a rock bottom for her, and she really did make some pivotal changes following that hearing.
3 months ago? 2 months ago?
I believe that was in October, yes.
Okay. Okay, because in July, we had drug screens positive for THC and buprenorphine and Suboxone without a prescription. She was waitlisted for Orchards, but was working with Linda Edwards and only attended 7 out of 23 visits. So I guess I'm wondering what actual period of sobriety we have that we're working with for Ms. Boker. And I mean, she also had a no contact with the person she's now living with. It just seems like there's been a lot of really significant changes in the last 3 months. And I'm concerned about how we can count on that being stable moving forward if we close jurisdiction. Could you speak to that?
Yeah, I do want to clarify. She moved back into the Brooklyn address, which is Miss Boker's maternal grandparents. The no contact was with her own mother, and that has been lifted from my understanding, talking with probation officer Cora Gibson about that. So she's not living with the relative that there was a no contact order. My conversations with both of them is that they do appear to understand how that came about and how to move forward with it. I have yet to see any conflict in their contact with each other. It's been mostly beneficial and supportive of each other. And it's something that they were asking for even before that was lifted, was how to support each other in this next role. And I apologize, you asked a question before that, and I literally forgot it.
Is she living with the children and the place? Okay.
No.
All right. There's a lot of family members here.
Yes, ma'am.
And it was not entirely clear from the report in my notes and comparing these things. So the other issue, the big issue that I'm grappling with is the significant amount of changes that have happened in the last 3 months and a sobriety period that is really less than 6 months at this point. And whether or not that could affect the stability of the children moving forward if we were to release jurisdiction.
I would be asking for the children. I understand the LGL had requested the children be returned to mom, but right now I would be requesting the children remain with Mr. Fox, as he is the non-respondent parent, but they have proven to be able to co-parent. He has proven before when she has caused issues that she will contact law enforcement to keep the children safe in his home, and he has continued to do that.
As of the last report period, Ms. Boker was looking forward to another member of her family with Mr. Fox. Are they still playing together?
They have kept their distance when the children are around. I haven't, in my conversations with Bentley, I obviously have not had deep conversations with Brody. Mother has not had access to the children outside of what the department has allowed. It does appear that they do keep their communications outside of the children, away from them.
All right, so do you know if they intend to move the children and move in together immediately if the jurisdiction of the court closes?
That was not my understanding. My understanding that was Ms. Boker was continuing. Right now she's unable to seek employment due to her pregnancy, and she's had some difficulty obtaining jobs. My understanding is that she would be seeking independent housing with his support following the end of this case. Mr. Fox also cares for his grandmother, and so she's also priority in his home.
But the children are residing with grandparents, is that right?
They reside Monday through Friday with maternal grandmother, and then they reside with Dad the remainder of the week, yes.
Okay. But there's nothing legally speaking to maintain that arrangement in place if the court releases jurisdiction. Okay. Redirect, Ms. Thomas?
Yes, Ms. Kopis, as it relates to the court's questions of you, what is your understanding of where the custody case is between Mr. Fox and Ms. Boker?
My understanding is that we had a hearing today regarding that matter, and the hope for the department was that Mr. Fox would continue with his custody of the children. I'm not sure how it's worded. I apologize.
No, that's okay. All right. And at the last hearing, the understanding was that the children were released to Mr. Fox under the supervision of the department. Is that correct?
Yes.
Okay. And do you believe that there would be any change to the children's routine without additional court oversight through the child protective proceedings?
I don't believe there would be many changes to their routine.
Okay, thank you. Okay, I have no further questions, Your Honor. Thank you.
Questions, Mr. McGrath?
Just one. If my client were to stipulate to father in this custody case having physical custody with parenting time is agreeable with father, the agency support that as being an acceptable outcome?
We would be supportive of that. Mr. Fox has proven that he is able to keep the children safe. Yes.
Thank you. Nothing further.
Questions?
No, Your Honor.
Okay, thank you for your testimony. May I return to your seat?
Thank you.
Any other witnesses today, Ms. Thomas?
No, Your Honor.
Mr. McGrath?
I'd like to call my client, Your Honor.
Okay. right. Walker, come on up.
Before I begin, I just want to let the court know that my intention is to ask her about custody and then call Mr. Fox, if that's okay with the court.
It's your case, Mr. McBrown.
Thank you. I thought maybe we could kill two birds with one stone rather than two hearings. I don't know.
Well, we'd have to call them concurrently. We're on record only in one matter at this point.
Could we possibly then call them concurrently? I can't represent her on the custody case, but I can ask her those questions on this case.
Well, clearly I can take judicial notice.
Sure, we'll do that. How would you like me to address you today?
Oh, you just call me Heather.
Okay. Would you say that Ms. Copus's statements about your progress are accurate?
Yes.
And I know the court has some concerns about the shortness of your sobriety, about 3 months. What do you have as far as supports if you feel an urge to relapse?
Well, like Ava said as well, you know, like the whole custody with my daughter and with all this going on, it really upset me, honestly. So it just, if I can't do it for them, then I can't do it for myself. So
My question would be, who would you contact if you feel the urge to relapse? Yeah.
my mom or Anthony, and I live with my grandma, so I talk to her a lot.
So you have family that you would immediately contact?
Yeah.
Okay. You and I have had a brief discussion about Mr. Fox having full physical custody of the children. Is that something you're agreeable with?
Yes.
Your parenting time as he determines to be appropriate. Is that also what you're telling me? Okay. You think that you and he can work things out as far as the parenting time issues, holidays, things of that nature?
Yes.
State everything that you wish to state?
Yes, sir.
Thank you. Nothing further, Your Honor.
Questions, Ms. Thomas?
I have done, Your Honor. Thank you.
No, Your Honor.
All right, so the arrangement currently is that your children are staying with grandparents during the week. Is it your intention to leave that in place?
Yeah, I don't plan to uproot them again.
Are you going to be asking the court to make that part of the order in the custody and visitation case?
I would allow that. I would allow that to where they stay with grandma. Does that mean I would be able to go stay at my mom's when the kids are there?
That would be up to, if the court is closed in this jurisdiction, that would be up to whoever's, your mom, whoever has the kids.
Okay.
Okay, questions?
No, thank you.
Ms. Thomas, questions on my questions?
No, Your Honor.
Mr. Howard?
No, Your Honor.
Thank you for your testimony. We return your seat.
I will call Mr. Fox, Your Honor.
Thank you. Okay, Mr. Fox, come on up.
I must apologize and I didn't warn you I was going to call you, okay?
All right.
How would you like me to address you?
Mr. Fox is fine.
Mr. Fox, you heard my client's answer about custody. Is it your desire that you have physical custody of the children?
That would be in the best interest, I believe.
Okay. And do you believe that you and mother can make a mutually agreeable parenting time schedule for her?
Absolutely.
You heard the question the judge asked about the children remaining with her mother while you're not available. Is that what you would wish to be incorporated in that order also?
Yes. So my youngest son, Brody, if you start messing with his schedule, it messes with him mentally. So we need to keep that the same.
Anything else you wish to add today?
No.
See if any other attorneys have questions for you.
Ms. Thomas?
I have done, Your Honor. Thank you.
Mr. Howard?
No, Your Honor.
Thank you for your testimony. We return your seat.
No further witnesses, Your Honor.
Anyone you'd like us to hear from today, Mr. Howard?
No, Your Honor.
Very well. Comments in closing, Ms. Thomas?
Thank you, Your Honor. I understand the court's position sort of on the recency of the stabilized progress that we're seeing in this review period. I believe that the department can no longer meet its burden in saying that there's a risk of harm to the children. We're proving that as relates to mother, considering that the children have a non-respondent father, all of the family members are in support of the two children that are in this court's jurisdiction to remain in their current living arrangement. And so I would defer to the court's opinion on, whether to terminate jurisdiction or not. But we do want to acknowledge that Ms. Boker has made significant progress in this review period. Thank you.
Mr. McFarland?
We would ask that jurisdiction be terminated. We understand that the children would, at least my client's opinion and Mr. Fox's opinion is that the children would not be returned to mother. They would be residing with father. He'd be making decisions about mother's parenting time, and they appear to be on the same page with that. So I think there's safeguards in line. Thank you.
Yeah, I'd just like to reiterate that I'm of the belief that the risk of harm with mother is passed, and that the support system surrounding the family is very strong and in the best interest of the two children.
To
terminate jurisdiction.
Okay, thank you. Well, the court finds all interested parties are given notice for purposes of today's review and permanency planning hearing. The goal of reunification is appropriate in this case. The goals of the services are, I would say, at best in progress as it relates to Ms. Boker. Balancing that against what would appear to be potential stabilization for the family, even taking a break and looking at the circuit court case does present a way forward for the family that would allow the court to release jurisdiction. However, that has not been put into place as of yet. And I do have a very brief period of sobriety from Ms. Boker. So I am going to extend the case for one additional review period in order to see Ms. Boker's continued sobriety and the finalization of stability as it relates to the two children under the disposition of the court, as well as to allow that DNA testing to take place as requested by Ms. Kopis. This is a situation where we've had progress up and down. Obviously, the involvement of Mr. Fox with Ms. Boker as well. I'm going to leave it at the family's discretion as to whether or not, when, and how to allow Ms. Boker contact with the children. And we'll see how they do in the next review period with the ability to work nearly independently, but still with the support of Ms. Kopis and the eye of the department and the court on the situation. For example, if something happens at the pretrial, we're in the very serious charges currently leveled at Ms. Boker result in incarceration or something else. That could be a major change for the family. A relapse could clearly be a major change for the family and for Ms. Boker and for the condition of the child that she's carrying at this time. Ms. Boker knows, I've spoken to her about this before, that any use of substances during pregnancy is considered a contemptible situation by this court and could potentially result in incarceration in order to ensure the healthy development of the child during the pendency of the pregnancy. There's just a lot of really serious things on the line. And I'd like to give the family a chance to demonstrate that they're able to manage it in the way that they have asserted that they can do. And so that will be the ruling of the court moving forward. Children will remain under the jurisdiction of the court, but released to Mr. Anthony Fox, as well as the youngest child to Mr. Valentino, with the parenting time to be as determined by the family. And Ms. Kopis will just be keeping an eye on things and doing some either random drug testing or checking in with the probation department or pretrial services, wherever it may be, to ensure that Ms. Boker's continuing her sobriety path and those services to support that.
Yes, ma'am.
That makes sense?
Yes, ma'am.
Okay. So let me give you a review date, a slightly shortened review period. Let's see.
Madam, if I could just make a note for your calculations. The DNA is, I know we're waiting on that as well, isn't scheduled till about January 24th, 25th. And then we usually say approximately a month after that to get the results. So just if you're adding that into your math.
Thank you. I was looking at the afternoon of Wednesday, February 26th. At 1:30?
It
Does that work
might
for
be
everyone?
better. I was just say, just might be better to go out one more week just in case there's slow processing in the DNA.
I'd love to accommodate that, but I have a trial scheduled for that entire week.
Okay.
And then unfortunately after that, it gets into a lot of other very busy.
Yeah.
days.
I will be on top of them for these results.
Yes, so just let us know. We'll try to carve out some time if it's not done by that point. So short review period. We'll see what the family does with it. But I am maintaining the jurisdiction of the court until at least the 26th of February at 1:30. That'll be our next review and permanency planning hearing. Unless there's any questions, that's all for today.
Should my client wait for a copy of the order or be emailed to her?
She can wait for it, and also we're gonna be on record in the circuit court case in a few moments, so she's gonna be.